Item number 1501.
We have allowed the appeal and restored the order dated 7/8/2023 passed by the NCLT Kolkata bench. Resolution professional shall act upon and implement the said order expeditiously.
Item number 801.
16th September,
Item number 802.
not to be deleted.
Malad, 802, I am appearing for petitioner. Malad. If your lordship could have it after 3 weeks, I need to file my rejoinder.
Not to be deleted.
Let it come up on Malad.
Because I need to file my rejoinder. They've just served me the counter last week.
Very well, then what is the point? It will be listed and adjourned again.
Malad, the only
Any date after 3 weeks, Malad.
if I may, Malad, only request, make one request, Malad. Malad, there was a direction for the matter to be listed sometime in April. Malad, the counter is recently filed. Malad, I bow down to that. Malad.
2nd September.
Malad, sometime in August. Malad.
2nd September, Council.
If I may request for last week of August. Malad.
2nd September. What difference does it make last week of August and first week of September?
And Malad,
September is inauspicious for you.
Malad,
Then what
there's
is
a stay order. Malad,
What is the
sometime
difference?
filed in our-
A few days difference. It's going to pinch you.
Malad. May I
Just arguing for the sake of arguing. That's
may I then only make one small request, Malad. Their
You
request,
already made one. Now, second, what?
Malad, their request for rejoinder, Malad, may be noted, Malad, if they can file it before the next date of hearing.
If you will file it, I'm sure you will remind us that they took time for that.
Malad.
Grateful, Malad.
803.
Not to be deleted.
Yes, sir. I'm grateful.
Item number 804.
Yeah.
October. As item 804 was item. So the last order. Yeah, October.
May I have the liberty to mention, Malad, item which is listed as 102 for tomorrow, Malad.
Adjournments tomorrow, please mention when the matter
It's
reaches.
an old appeal, Malad. I require 2 weeks time to prepare.
If it's an old appeal, all the more reason that you
That's
should
why,
be
Malad. That's
prepared.
why to be assisted
Why?
to the court, Malad.
Midnight oil today.
Yes, Malad. But there are old document 2005.
Whatever it is, you have the whole of tonight. One night sleep you can miss for.
Malad, I tried my best, Malad. Just two
No,
weeks.
no. We are not going to adjourn like this.
Let's see.
It's an old matter, you should be ready for it.
Yes, Malad. That's why.
When old matters are listed and you don't get ready, it reflects poorly on the council.
Full court judgment by the High Court.
Whatever it is, you get ready by tomorrow.
Are seeking an open court hearing of the 130 matter which in chamber. Well, the legally appointed untainted teachers cases have not been presented.
We'll look through the review petitions. Yesterday mentions were made. After we look through the review petitions, I've already been briefed about the contents. Let me go through them. Depending on what points you have raised, and we'll take.
Well, only submission is that I'm not on the point. It is they are within the panel validity, and they are within the destruction of OMRs. Well, that is within 1 year. Their cases have to be considered. CBI or SSC have not filed any charges against them. They contribute to a major extent, almost 85%.
All those aspects were argued, Mr. Janjala. You did not appear in the first round.
Yes.
Then all these aspects were argued.
One.
Also.
Please, Malad.
This is for the petitioner. Petitioner, no one? Anyone online?
One.
Malad, the law.
She did not join the mediation at all.
No, my lords.
This mediation order was passed with the consent of the council, the party.
Yes, my lords. Both the parties concerned.
They consented. It was not because we did not pass the order, and the order does not record that the parties wanted it. So we had a doubt whether it was the court which directed mediation or whether you agreed to it.
We agree.
You agreed to it.
Yes.
And then she doesn't turn up at the mediation.
No, my lords. For the 4 occasions, my lords.
At 2 o'clock.
Yes.
By 2.
No. She's not to.
In case the list gets over before lunchtime, then we'll take up the password. So please keep track of how the court is progressing, the list is progressing.
Number 2.
As I'm appearing for the respondent husband, my lords.
Yes, counter is fine. Move on for the petitioner.
On the last occasion, my lords, we tried to mediate. My lord, the petitioner wife didn't want to participate or settle the matter. So we can proceed on merits, my lords.
Mediation was there?
My lords, we requested for mediation, but there was no formal order passed.
There was no order.
Yes, my lords. We tried to mediate, but it didn't take place. My lords.
You tried to meet.
I tried to mediate, my lords. The settlement was not agreed.
Password.
Grateful, my lords.
Item number 3.
Respondent can get appeal. Let the matter be sent to mediation.
They are not willing for mediation by the looks of their counter.
Willing to, my lord, settle the matter. If he comes out to some certain terms, my lord, we are willing to.
You are willing to. Then you want to go.
Definitely, my lord.
You want to go for mediation.
Instead of mediation, my lord, let him come up with some proposal.
Why don't you make an offer? There's no. You see the dues as per the counter.
Please, sir.
18,46,477. The principal is 11,73,000. So even if they do waive interest to some extent,
Yes,
how much are you willing to offer?
so for my instruction, let it be in the principal amount. That in the bill settling
Some portion of interest.
Some
my lord.
already over.
You have to pay. You can't say that.
Let we.
What did you do with the car?
This is number 6.
Still using it.
Oh, you want?
My lord, my lord.
But you don't want.
There is nobody to use it.
Home loan, home is also retained, car is also retained.
You are in item number 4, you are for whom?
Personal loan and
For petitioner, my lord, there is settlement going on in this matter.
For buying a car and buying a home.
No, we are only-
Bhavna Khowal.
You are now enjoying.
therefore we are on
2
completely
weeks,
on
we
the
will
line
do
of all
this
these
time.
things.
File, 142.
Highly
We have
obliged.
given the figure
Highly
page
obliged.
1846 and interest is 590.
Item 6 is there.
With interest, it's this. So even if they waive legal charges.
Because I would like to withdraw this present petition.
You want to withdraw? Okay.
Yes,
You
Lord.
pay 15. You pay 15.
15 lakh.
I will have to track it.
I'm appearing for it.
This is not, I mean, like, as far as my instruction for this.
Petitioner is seeking a transfer of guardian petition in order to.
My friend,
They are not there to just give money free of cost. Is
No,
it?
no,
You want to pay only the principal
I am not.
while you're retaining the car and the home.
No, I know, I want to sell the car also.
Then sell it and
there was nobody.
what car is it? The luxury car, what kind of car is it?
Fairly, we are somebody.
What kind of car is it?
No one is.
What
Just
kind of
pass it.
resale value does it have?
Now almost nil resale value.
Appeal for the respondent.
21.
Transferable civil
Why civil suit to be transferred?
What has happened?
To
After
make
my
this
marriage, my
have
husband is
higher
there to
resale
the
value.
US
Let
and
us
then
come
when
with
I
the-
went
just
there,
because
involved in certain immoral activities. He forced me to that. I somehow returned back. My in-laws just filed
Lord,
a
I am
civil suit
prepared, my lord.
against
Whatever
me and my
comes,
husband
Why
is
don't
suing him
you
which was
don't have to
permanent.
negotiate?
But the problem is I am deciding
Comes
his
to the
money.
parties.
I'm unemployed. I'm totally dependent on my
Rani
savings.
to Karnal is not very
To see
far.
whether
And you are
settlement is
different,
possible.
No, I'm the petitioner.
And
In civil suits.
In the civil suit,
this
she
one,
is
how much time will
the
they require?
no?
and the property is located in Karnataka.
3 weeks.
I also understand it's a civil suit, but
You want to put up the suit as long as possible.
then permit, ask them to pay the traveling expenses whenever my.
I am not the husband.
19,000.
Obliged.
Civil suit you want?
So
Expensive.
this is complete.
This is complete in this matter. In fact, filed.
I appeal for the statement.
No, I will not.
I appeal for the statement.
Today, but record is required because.
Answer.
No, this is after notice only.
In fact, it is
After grant of leave, the record will be
Insufficient address. Second, also no such person.
There is only one thing I wanted to point out.
Is the record required though?
No, because my lords, there are two exhibits.
Lord, according to his
Which specifically mention that two different persons were there who committed the crime. And one of the accused was also
Item number
mentioned.
11.
But that document creates doubt. about the case of the prosecution.
I echo the respondent.
Yes, but the appeal of the lord is already dismissed by your lord.
Party
That order I
send the matter to mediation.
Well, this is the order.
Mr. Counsel, what do you say?
Usually by appearing in item number 11, your lordship.
He says mediation.
Yes, my lord.
But the role of the petitioners will have to be looked into.
What is that? Then you want us to, not a case for granting of bail at this stage. Father has cancer, your brother is out, he's in the army.
Even my lord, the
He can take whatever
outside, my lord, he is
measures are
outside
required.
is suffering with the AIDS and his immunity is quite low. Then, my lord, can it be done? May I request for hearing of the matter along with the record?
This leave is granted, they won't get it. The state is directed to requisition the trial court right immediately. Each copies of the appeal shall be furnished to the learned counsel of the parties. Yes, the appeal for hearing on. Then when do you want?
So after
Perhaps take 2 weeks at least.
yes, 3 weeks. After 3 weeks.
These copies may or may not be
Yes.
ready. Bombay, they should be yes.
Yes.
Copies would be available.
Yes. Any Wednesday, my
No, Wednesday it won't come
We can
unless
hear-
bail is out.
Finally.
Come up. 28th August. Bereavement in the.
They filed a letter for adjournment. There is a bereavement. Can it be in the first week of September?
The then counsel for the petition filed the letters seeking an adjournment on the ground that there is a bereavement in his family. Notice accordingly adjourned, list on 2nd September.
Item number 6.
There is 6.1, you know, so I'm requesting for some time to file my counter. Notice of issue on 27, I filed my just yesterday lordships. Madam, there is 6.1.
6.1 for the respondent.
Yes, madam. Notice of issue on 22nd July lordship. And I
There
filed
was
my
one other matter.
That is item 6. I'm seeking
No, other than these two, one matter where Mr. Raju was at.
Mr. Raju appears in 6.1.
6.1 is it?
6.1.
Very good. So these are the only two.
Yes, these are the only two matters.
You want time to
Yes,
file the
for which time to file my.
in the first item, 6.
But I'm seeking a Passover.
No, both will have to go.
Yes,
together.
yes.
6 someone is appearing to.
Yes,
We appointed counsel.
She is appearing.
No, for the respondent.
She is appearing for the.
You are appearing. You don't need to file a counter. Well, it is purely a legal issue. Right. When counsel appearing for the respondent in SLP criminal number 8, numbers 8223, 8224, 2025, 6 time to file after the black, which should be done within 2 weeks. Rejoined at their 2 pending, if we filed within 1 week thereafter. List on 9 September.
3 weeks since he's in. Well, my only request for 3 weeks since he's in judicial custody. I have to get the.
3 weeks and 1 week. 3 weeks, 1 week, 9 September.
It's a neat question of law.
He is entered appearance now. Very constant.
Oblige, madam.
Lordship, I am appearing for the petitioner.
This proof of the deposit.
Yes, Lordship, we have filed it.
You filed it, but you'll have to explain exactly what it is.
Lordship, 14th of May, 4,50,000
What
rupees.
is the amount that was transferred into her account?
550. 5,50,000.
You filed a document, is it?
Yes, Lordship, we have filed a bank statement showing.
Not here.
Second file, second.
14,000
The office report
along with the office report itself. It is.
Along with the office.
Which we have in the copy. We have downloaded the
This,
14th of
what is the
14th,
amount?
not say 14th of May, 4,50,000. 14th of May, 4,50,000.
4,50,000.
And kindly comes to Lordship, 18th of May, 1 lakh rupees.
18th of May.
1 lakh rupees.
No, but we don't know what the account number is. Only the net transaction.
Lordship, bank statements.
We have received it.
You have received the amount. Why don't you file a document to that effect? This doesn't indicate anything.
Unless we will file there.
We don't know what your account is. If there's no mention of an account.
Lordship, this money has been transferred to the account number provided by the respondent number 2. In fact, once we download the account statement online, generally we get this kind of account statement.
Account numbers are also different.
In any case, we will file the app.
Lordship, this is not the account number. Basically, this is the transfer number or UTR ID. This is basic.
Also seem to be different. 308, 309. She has two separate accounts.
No, Lordship, may I explain? This is basically a UTR number, basically.
Transfer 2 would be the account number, perhaps, because the UTR number is mentioned there under.
Right.
NEFT UTR number comes underneath that.
I
number must be the account number.
I undertake to file proper bank statement.
Not you. Let the other side file an affidavit. The lady's affidavit saying that she received this amount first. Mediation has failed. Then?
Lordship, mediation had failed. In fact, the one.
You want anticipated bail?
He has come forward.
Yes, Lord.
Where is the question of granting you anticipated bail? You're supposed to have beaten her up again after being on interim bail.
Lordship, what I had been directed to deposit the interim maintenance granted by the alternate tribunal.
Not as a guarantee that you will be granted bail.
So definitely.
Bona fides. Because to begin with, you beaten her up after being on the interim bail.
Lordship, what I am requesting?
Where is that injury report? Let us see what the extent of the injuries are. Injury report.
May I explain? May I explain in 1 minute?
The High Court refers to it.
High Court, in fact, Lordship, the High Court referred the matter before the mediation.
Mediation has failed now.
Lordship, that exactly I just please bear with me for a moment. High Court sent the matter before the mediation. In first round of mediation, matter was settled. But once the matter reached before the Honorable High Court, it was pointed out that the payment description, actually matter was settled in 6 lakh rupees in total. It was pointed out before the Honorable High Court that the breakup of the payment is not clear. That's why the Honorable High Court sent the matter.
Of this injury report, which is referred to in para 5 of the impugned order, the injury report, you have not filed it either.
That will indicate in the next.
Lordship, can you give
let us at least see what the injuries were.
Lordship, there is nothing like injury.
To have you outside.
Lordship, may I just explain, Lordship? There is nothing like injury. Why?
You don't file the injury report and you claim that there's nothing like an injury.
Lordship, I have filed the medical document.
But the report you would have filed it. The very fact that you did not file it means that we should draw an adverse inference.
Lordship, I have filed the entire document.
Injury report first.
Lordship,
injury report referred to in para 5 of the impugned order shall be produced by the learned counsel for the petition.
Lordship, may I explain? I have filed the medical document. I don't have any such injury report.
Indicating as to whether or not the amount directed to be deposited in her account has actually been so deposited.
Lordship, may I
2nd September.
Sorry to interrupt, Lordship, but may I explain?
For the injury report, you say nothing.
Lordship, I have filed medical document, in fact.
Where is the injury report?
Lordship, they have not filed any such injury report. The respondent number 2, whatever document.
In the High Court order. Either of you, please produce it.
Lordship, kindly have page number.
Counsel, we have already adjourned the matter. Please produce the injury report.
Lordship, what I am requesting, I have filed the entire document filed by the respondent.
You have said enough. You are not answering the question that we posed to you. There's no point in wasting time further.
Lord, in 8, I have not got the documents from which they are relying upon, the medical report.
No, it is only a medical report.
Only the report is there.
You have not received it.
The documents are not.
What documents? There's only a report.
There are a lot of supporting documents.
There's
there's only one medical report which was
no,
on the last page.
annexes to it.
There is.
There is
No, there are no annexures.
Last time
We only directed the report to be furnished.
Sir, you were not present on the last date
I
of
was
hearing.
not present.
So we gave, we directly
only to consider the medical report, that's all the limited question
Yes.
was.
No documents.
Learned is having the medical.
Mention the date of the report also.
My learned friend is having the medical report.
Then
I have the medical.
So that's the only
I'm
document.
not saying.
That's the only document.
I'm only saying.
Medical report dated 9/7/25. That is all that is said. There's nothing further. Mr. Vikas Singh, that is all that is there here. So going by the medical report, is there any necessity for him to be
Just
out?
not the opinion.
He is obese.
No. Obese is
So
just
being in prison would at least bring down his weight. Just forced dieting.
see the opinion, Lord. Just see the opinion. It's not obesity is not a problem which for me.
Look at the rest of his
No,
problems.
just see the
Totally manageable inside the prison itself.
Lord, just see the opinion, Lord.
And look at the amount involved.
Not amount for the amount my brother has been already rejected. He is already
34,926 crores.
The main
Is that the figure?
Yes.
100 accused, so each of them gets 349 crores. Even if we take it that they equitably distributed it amongst themselves.
I'm not
100 accused.
I've already remained inside for more than 4 years.
It's not a regular bail, it is only medical bail.
No,
Medical ground, where are the grounds?
So just see the medical bill. But just see
Please show us which of these grounds, or rather the issues, medical issues.
Just see page, Lord, the last opinion of the medical board, Lord.
Yes.
And there is no mention of obesity.
He requires, there is a mention of obesity. The
Second last one.
order, the report begins by saying that he is
10
obese.
doctors have started the sign, 11 doctors have signed, Lord. Just see what they say opinion. At the time of current assessment, Dheeraj Nagwan requires regular and periodic.
I gave it back to them. Office report. The second one. Second one. Yes, Mrs.
Just see the opinion first and then I'll show your lordship's here.
Yes.
Part. At the time of the current assessment, Dheeraj Nagwan requires regular and periodic follow-up with the Department of Nephrology and Urology for urinary.
Those kind of things they will take care of.
No, follow-up can't happen. Not your lordship.
Why not?
So your lordship knows.
Do you have a hospital attached?
No, you have no good
Medical facilities
Some
there.
years
There is always a jail hospital in the jail.
And wherever he needs.
Specialist required. This is not.
They never said that any particular specialist treatment is required.
No, this is, they mentioned a specialist.
Continuation of physiotherapy. So you,
No, please see.
out of that 3,496 crores, you pay some physiotherapist to visit you in prison.
Just see the.
So he can come and give you the physiotherapy
It's
session.
not a case
in jail itself.
where
It's not a case where he should be
once
out.
not medical bill.
Not on medical grounds.
Have dismissed the SLP against.
Not on medical grounds.
Your lordships have earlier dismissed that SLP on medical bail only. Lord. Just see,
No.
just let me just read the whole.
Earlier he might have been in a worse
No,
situation.
same,
Now he is
same position. Just see, Lord, what is the, just let me read the whole of it, Lord. At the time of the current assessment, so also requires regular and periodic follow-up with the Department of Nephrology, Urology for urinary complaints, neurosurgery and orthopedics for his spinal ailments, including continuation of physiotherapy as part of his treatment plan as an outpatient basis and other.
outpatient basis. He doesn't even need hospitalization.
Doesn't mean not that the hospital will be, jail will become a hospital. Jail can't become a hospital.
Every time,
For every specialization that he has to.
Let him go.
taken.
Not every specialization.
He makes out a point, then we'll come to you.
Very well. I'm
Not
On the
every,
face of it, we don't find anything.
not every, just.
Come to each thing, general medicine.
No, just
Patient
see
is
now, just see
asymptomatic and has no active medical illness. Dermatology, no active treatment
Just see
required.
neurosurgery.
General surgery,
Just see
no active general surgery complaint.
No, Lord, just see
Asked to continue ongoing antacids.
neurosurgery.
Psychiatry, he is advised to continue ongoing medication.
Just see.
Cardiology, advised to continue ongoing cardiac medication. Pulmonary medicine, advised to continue nocturnal CPAP. I'm told by my brother, I don't know what this was. He says that it's some kind of machine which
Even I am
helps
using
you
it.
sleep.
Small machine.
No, it's a sleep apnea machine.
Whatever it is, it's a machine. So
The apnea-
again, use part of the 3,496 crores by your own CPAP machine.
Not CPAP is not an issue, Lord. CPAP is not an issue.
50,000. Very well. It's only 50,000.
CPAP is not an issue at
That
all.
also can come out there.
Lord, I'm not on CPAP at all, Lord. That's just see, Lord.
Look at the rest of them. There's
Just
no
see- just see
complaint which requires
neurosurgery.
neurosurgery. After reviewing, he's advised to continue back strengthening exercises and physiotherapy.
No,
Both of which can be provided.
No, just see.
And advised to follow primary surgeon where previous
Lord,
surgery was done.
Lord, ultimately-
If you need periodic
I have been
checkups,
inside
you
jail.
can be taken
Lord,
to the hospital
there has
wherever
been-
your
Lord,
surgeon is. That does not require to be set at liberty.
Lord, I have been granted regular bail by Lucknow, no challenge by the CBI. Against the Bombay, your lordships have dismissed the SLP. Against this order, Lord, just see neurosurgery, Lord. Just see neurosurgery.
We've seen neurosurgery. All
No,
that
just-
you are required is back strengthening exercises, physiotherapy,
No,
and
and
follow up with the primary
primary
surgeon.
surgeon with previous.
Follow up, which doesn't mean that you go to see him every day.
No, but Lord.
A follow up would be once in
Lord, I
say
have
3 months or 4 months
I
or
have
6
the
months,
privilege,
you
Lord,
know,
to assist your
depending
Lord.
on what the
Matter
doctor
where, Lord, a specialist is to be consulted, Lord.
Where is the
Wherever
specialist?
all these, because the final opinion is to consult the specialist.
Urology, he was advised no active management at present, advised to get
Otherwise-
nephrology consultation.
Otherwise, please.
Nephrology, he was advised to follow up in nephrology OPD in 3 months. So once in 3 months, you need to go.
Lord, no,
Orthopedics, advanced physiotherapy, back strengthening exercises, and shortwave diaphragm.
Lord, regular follow-up with a specialist. When you
Sorry,
need,
Mr.
Lord,
Vikas.
nephrology,
This is not a case where you should be out on medical
neurosurgery
ground.
and orthopedics, Lord, a specialist for all these. Then, Lord, it is not possible for the prison to get me to the specialist every time, Lord, I
No,
require.
whenever he needs any specialist treatment, please ensure that he is taken.
Lord, that will not be possible, Lord. This will
Right,
not
it's for them to decide whether it's possible or
Lord,
not.
your lordship will have to decide, Lord, they can't.
Yes, no, if he requires any medical care urgently, please ensure that he is provided such medical.
Regular follow-up.
Beyond that, there's nothing.
Lord, today, just two more things, Lord, and then I'll not trouble your lordships. This is an under trial. I have already spent 5.5 years in jail, total 4 years in jail. And Lord, ultimately, there are how many witnesses? More than 600 witnesses. This trial is not, this is never.
That is not the ground on which bail has been.
Near future, if your lordship want me to serve the
How long
sentence-
was he inside though? He was arrested
4
on
years.
19 July 22nd.
4 years, not total.
Released on, no, 4th, in April 20, you were arrested, released on bail in
4
May
years.
24. There you spent about 4 years.
4 years.
But
And
after
under
that, you were arrested again by the CBI in
But
May
as an under
24.
trial, 4 years, Lord,
And you've been granted bail in September 20.
Lord,
So there you only 4 months.
4 years total, Lord, I've spent in jail. Ultimately, Lord, if there is no possibility of the trial taking place, and I'm not, Lord,
Considering
like,
this kind of
Lord,
figure,
Lordship still, Lord, whatever.
17 banks have been.
Lord, whatever, Lord, even, Lord, the grosses of.
What are these banks doing? They just get ready to be taken for a ride.
Under trial, your Lordship.
17 banks.
The purpose is not, Lord, for making me suffer the sentence as an under
Well,
trial. I mean,
you've
that is
taken
not-
care of 10 or 15 generations to come.
No,
So it doesn't
that's
matter
not-
whether you're inside or outside.
See,
Any amount recovered out of this?
company has taken over by pyramid, Lord. Company is already taken.
Proceedings are also there. Maybe something has been recovered. Some of the property which he acquired was of a don called HON'BLE Mirchi. His property is a and money, lot of money is left.
Can I, Lord, then request one thing, Lord? I just make a last request. On merits,
The
Pyramid
employer has given
just
us
one second.
on merit.
Pyramid has taken over.
I'm sorry, Malad.
Pyramid has recovered 80% of the total outstanding. Then let me place all that on record. Lord, ultimately,
That is a
Lord,
draft for a regular pain,
your lordship,
not for medical ground.
then your lordship will give me liberty then.
No, we won't say anything. You don't need liberty to file a
Otherwise,
bail
Lord,
petition.
the
In circumstances, you're
impure order, Lord, deals with merit also. The impure order deals with merit. If your lordships are feeling that it is only medical based, then
That's a separate ground altogether. They're not
no, so
going
your
to
lordship
say
may
anything
then at least record my statement, otherwise, Lord,
They're not going to say
If
anything. You
supposing-
don't need that
if your
door open
lordships
for
are
you. Mr.
prejudiced,
Singh.
Lord, if your lordships are prejudiced today by
This
the
bail is on medical grounds.
on medical ground,
So
Lord,
far as medical grounds are
medical
concerned, you are not
ground,
entitled.
your
to bail
lordships
at
have,
this stage.
11 doctors have examined me and found that I
That, you've
require.
already said we are not with you on that.
Lord, I appreciate that, Lord, I'm only saying.
Once medical grounds go, it is always open to you to apply for regular
say
bail.
that.
There's no question. We don't have to say that. There is a question of res judicata in bail matters.
Lord, your lordship will just see the impure order, Lord, at the
The
paragraph.
Central Bureau of Investigation.
Just see the paragraph
is the
22.1.
applicant. It is agreed by the order dated 9/9/2024, passed by the High Court of Delhi in bail application number 2040 of 2024, whereby the respondent was granted bail in connection with in connection with his one on medical grounds. As
Lord, by remaining in jail, make them recover the amounts. Is the point, Lord, which the lordship also will have to consider. Ultimately, Lord, I can't be made to suffer the sentence.
by order dated 23/5/2025, this court noted the fact that the respondent secured bail on medical grounds and opined that it would be necessary to ascertain his present medical status. He was accordingly referred for examination of his health condition by a committee of doctors to be constituted by the superintendent of Grant Government Medical College and Sir J.J. Group of Hospitals, Mumbai. Pursuant to the said order, you already paid for the medical examination.
The case where he should be made to pay.
Pursuant to the said order, a team of 11 doctors.
Instead of bad precedent, Lord, if your lordship, if under trial is requiring specialized treatments, regular basis,
Understood.
never, Lord, any medical
Examination
examination granted in any matter.
Respondent and furnished report dated 9/7/2025. The health parameters of the respondent pertaining to general medicine, dermatology, general surgery, psychiatry, cardiology, pulmonary medicine, ENT, neurosurgery, urology, nephrology, orthopedics, and orthopedics were subjected to examination, and the committee opined that there was no necessity for any hospitalization, no any hospitalization of the respondent, and all that was required was continuation of ongoing medication apart from physiotherapy and back strengthening.
Lord, regular
exercise.
follow-up is specialized, especially.
The final conclusion of the committee was that the respondent required regular and periodic follow-up with various departments for his spinal ailments, including
All my doctors are
spinal
involved in
ailments, and also required to continue physiotherapy as part of his treatment plan on an outpatient basis and other concerned specialties for his ongoing medical conditions. in the light of the aforementioned report, it is clear that the respondent does not need to attend the hospital on a daily basis, whereby he could assert that he would be entitled to the continuation of the bail granted to him on medical grounds. All that is required as per the aforementioned report of the committee is that he should follow up periodically with the doctors concerned belonging to the various specialties. We therefore see no ground to continue the bail.
Your Lordship will have to direct them to give me to the specialist, not as and when required.
Needless to state, as and when the respondent requires any urgent or any specialist treatment, the jail authorities and the CBI shall ensure that he is provided such treatment immediately.
Of the requisite
Subject to
specialty.
the above, whatever the specialties be. Subject to the above, the
Lord, jail will be Delhi.
is allowed, setting aside the order dated 9/9/2024 passed by the High Court of Delhi in the application number 2040/2024. The respondent shall surrender within.
Your Lordship will give me 4 weeks.
Why 4 weeks?
Lord, I will also not in the meantime prefer regularly because your Lordships are not hearing
We are
your
not
merits.
giving you time.
Lord, your Lordships are not hearing your
Within
merits.
2 weeks.
Lord,
Within
in the
2
meantime,
weeks
your
from
Lordship
today.
will say I can apply for regular
Within
bail.
2
On merits,
Don't
I'm not
say
saying, Lord,
that.
your Lordships are not
Within
hearing
2
me.
weeks from
Lord, your Lordships are not hearing your merits.
We
So at
have-
least your Lordship may say I will be at liberty.
We may however clarify that this order has been passed only on consideration of the medical grounds on the strength of which the respondent secured bail from the High Court, and we have not gone into the merits of the matter.
Deeply obliged.
Number 9.
Wait, please.
Yes.
This comes up after notice. But offense under section 307, 2 years in
Back in the
jail.
police law.
Yes, what happens will not that they, there are 2 offenses related.
Those weapons and all.
I'll tell you Lordship what happened. Because my brother runs a shop, liquor shop. Now what they do, all these police people, they come and will not start assaulting the people there, and they say that you have
Police in Madhya Pradesh is
strike me. You know, that's what
They come and assault people randomly.
give me 30 seconds. What happened?
I want to understand.
Yes, you know, that's what happened. And I'll tell you because
They
it
go
happened.
anywhere and they start assaulting people.
But just give me 30 seconds. What happened? I'll tell you.
They find 24 boxes of illegal liquor.
Yes, and then there is an acquittal in that. The court finds there is nothing. We have annexed it.
Snatched weapons from the police.
Nothing, Milord, nothing. They fired a bullet. Petitioner was injured.
You hit a policeman with the butt of a.
That's what they say. That's what they say. In fact, they fired a bullet on me. And what their allegation is, Milord, that 70, 80
be allowed the citizens to attack the police.
So please see, this is not
Then where are we headed?
the truth. Milord, that's not the truth. Milord, therefore, Milord, please permit me to say something. Milord, there are 2 offences registered on 19th of January 2019. One was against my brother for withholding illegal liquor. That's what their allegation is. They say he had buried liquor in some soil when he should have kept in his shop. That was the allegation. Now, in that, the proceedings went on and there is an acquittal to my brother. Same day. Now, in this FIR, what they say is that this policeman, they had come to seize this bottles. And there was 70, 80 people, villagers, they started assaulting the police. And police fired on them, and that's what the allegation is.
80 to 100 strong mob.
That's what
coming.
and that
Then obviously they have to fire in the air at least.
no, they fired on the petitioner, and that allegation has found
Are
to be
you
false.
injured?
Yes, he was injured. He had a bullet in the stomach.
Where is
Blood, page 30.
And for 4 years he was absconding.
Blood, he was. What happened is, Blood, those other people whom they arrested, they were assaulted mercilessly because they are all police personnel. Blood, please see page 30. He was, Blood, he suffered an injury. Bullet injury. And he says, I was assaulted by butt of the rifle at 307. Please see page 30, Milord.
Yes.
This is the injury, page 31.
Where it is.
Page 31, Milord. If your lordship wound present, flank centimeter so and so. And this is by the government hospital. Page 32. Medical officer.
Anterior aspect. So the
Yes.
bullet exited. There's no bullet. You said there's a bullet in
No,
the
no, no,
stomach.
there is no bullet, but bullet injury. I'm saying bullet injury. And this is by government hospital, my lord. Please see page 33.
You are one of those 80, 100.
That's what they say. That's what they say. And only one person gets injured on the head.
This is
None of them. And see, my lord, 2 years in jail now. And please see the additional document. Kindly have a look at the additional document.
this is
Their entire case is found to be false.
this is which place?
Madhya Pradesh. What is
Where in Madhya Pradesh?
Datia will.
Datia. And please see the acquittal order. my lord.
Police station.
Datia, Bend Morena.
No, that's Datia is near Jhansi. Bend Morena is.
Yeah, same belt,
Same
belt.
Please see
There,
the additional
I
document.
tell you, a cop, IPS officer was crushed to death. Have you heard of it or not?
I'm from Gwalior, Manoj, I know.
You know that, no? So this is that belt.
This entire case is false.
Fortunately for you, my brother has personal.
But this is not such case.
What goes on in that location?
See the additional document.
The
Please.
widow is an IAS officer.
There are 10
You can't take law in your own hands, assaulting
all
police people,
independent
snatching their
witnesses.
weapons.
Lord, I am saying something. All independent witnesses have deposed in my favor. Please have a look at the additional document.
Obviously, if this is the kind of place it is, then I can
Have a look at page 30, my lord, if their case is found to be true. Sir, please see the additional document.
You have snatched weapons from those
Lord,
officers.
Lord, please see the
to
corresponding.
attack this policeman with his own weapon, is it?
That's what they
His
say.
weapon and then hit
That's
him on
what
the
they say. Once, my lord, he fires on me.
Only because
How
you
am
were
I
kind enough not to fire on him, we need to
Sorry.
let you up. You were kind enough not to fire, but only hit him on the
Fired a
head.
bullet, my lord. There are 70, 80 people. They say 70, 80 people.
And you were a senior citizen then?
Yes,
Now.
No, even then,
itself he was a
even
senior
then.
citizen.
No, see, nature, blood and 2 years in jail.
Senior citizen, at least the
Blood, see, these are the police, blood, they created.
a policeman on the head.
There are 2 cases created, made by them, lodged by them, 2 FIRs. One has turned into their acquittal. They found there's no substance in their
There's all
allegation.
the more reason to keep you inside because of the
This
way
is
that
that 63-year-old man now, 63, 64-year-old. Blood, the trial is in the midst. Blood, their witnesses have not supported them.
Offense of
What they
this
say,
nature,
what?
the signal
That's
that
not
you will
even-
be sending out by letting out a cop.
That's
Sorry,
not even
cop
a
attack.
307. Blood, assuming take the case as it is. Let's take the case as it is. Whether 307, is it 307? Is it attack
I
murder?
don't know what kind of injury he
Sir,
suffered.
there's only one injury.
The fracture.
There's not even a medical
Fracture of the
certificate.
skull.
Nothing.
Injury on the head.
Lacerated.
So one injury and 307. How is it not? How is it 307?
The X also, my lord. The
With
injury.
an axe also.
My lord.
No, not.
And
They say,
my lord,
so far as-
they hostage several of police officers, my lord.
Please see page 28. my lord. Please see page 28.
It is a very serious offense, my lord.
Please see page 28.
That should not have case.
All others are released on bail. All other accused, except
All others.
the one who is
They are
injured.
shorting for 4 years, my lord.
The one who is injured, he's in jail.
My lord.
One who is
Incident
fired.
happened in
All others are released on bail.
In
Next
2019 it happened, you went into prison in
23,
July 20.
September.
So therefore, 2 years in jail. I'll attend the police station every day. Please have a look at those orders.
My lord, he was absconded.
No, but have all the others
Yes.
are accused in
Yes, my lord.
released
One
on
of the
bail?
accused is still inside, my lord. Brajpuri, apart from the petitioner.
If all others are
How
released on bail.
many accused were there?
Total, my lord, 6 accused. 1 died, my lord, and 5 or 4 out of these, my lord, 3 has been released by the High Court.
Where are the bail orders
Yes,
placed?
my lord, page 43.
All of them?
Page, yes, all orders are running. Page 43 onward. Lord, it says he was in custody from so and so date, therefore released on bail. Trial is not likely to take place. Page 44.
But no specific overt act attributed to him.
Lord, please see the FIR, Lord. Page 28 is the FIR, and all these orders I have annexed.
28?
Yes, page 28.
Yes.
The police, third line. The police party using necessary force tried to disperse the crowd with lathi and batons with the crowd. With an intent to kill, started incessant firing of the police party, out of which 1 bullet passed near me. I got my life saved by sitting. Balram Puri came and hit the butt of the pistol in his hand on my head, which hit me on the left side of blood came out of my due to injury. That's what brush puri with the axe in the hand. I'm not brush puri, having the intent to kill, attacked with hit, which hit.
Brush Puri is out on bail?
No. The
not.
accused forcibly took the arrested accused Ravinder Puri from the possession of the police and dropped 2 rifles in which one so and so. So these allegations are against 70, 80 people.
Rifles have been recovered or they are also
Recovered.
recovered?
And Ravinder Puri has been released on bail.
Ravinder Puri is the one who was rescued.
Yes, no. Either Puri accused forcibly took.
He was the one who was being arrested and
Yes.
you people went
That's
and
what
got
they
him out
Now,
of the.
this entire story has found to be false. Because that's what I was trying to show your lordship, the additional document. The genesis has been found to be false.
What is that?
Yes, you don't have the additional document. Page 24 of the additional document.
24 is some report.
And please see page 25, the date of incident, 19 January.
What is this you're showing us now?
Now, this is the order of acquittal. On 19 January, there were 2 crimes registered.
Show us the relevant.
Yes, now please have a look at page number 30, first page 30. This is what the story is in this crime also. Para 2, the prosecution in case in brief is that on 19 January 2019, Amit Sahu sub-inspector stated that on the above date, he had departed for area patrolling. During area patrolling, he got information about the informer that husband of Rachna Puri, Sarpanch of village Rakhanpur, Ravindra Puri, has kept illegal liquor in huge quantities in his field and is selling the same. For verification of information reached at police of field Ravindra Puri at village Lakhanpur, Ravindra was found present. Search was then done. Then in the bhusa kept adjacent to his coatis, there were 24 boxes of desi liquor, masala quarter buried in bhusa on which high time was written found. License was desired for keeping liquor at the site of Ravinder. Then stating that he does not have, he started fighting. On hearing the sound at the site, Indrajit came. The illegal liquor was duly seized before the witness Indrajit. Constable so-and-so and the accused Ravindra Puri has asked to sign on the seizure. Then Panchanama was prepared. Later, the act of accused being punishable under so-and-so. Accused did not even sign on the arrest Panchanama. And then, your lordship may see, later departed to take seized goods and the arrested accused to the police. Then near the field of Ravindra Puri, a crowd of around 80 to 100 persons came with Laki, Farsa, Danda and so-and-so. They unanimously surrounded the police party and started attacking. They gave beating to the police party with Laki, Dandas and Farsas and so-and-so, so-and-so. This is the story in this case also. Now please have a look at page 46.
Yes. So out of the 24 boxes, only one is produced before the court.
Yes.
What happened to the other 23?
23 were robbed, my lord.
Why would they leave one alone? If they took off 23, they left one for the purpose of evidence. Or your officers took them.
My lord, one was
24 were consumed by the investigating team.
there was, my lord, they robbed entire the boxes, my lord.
So one they kept for production and 23 took home.
Reason, my lord, they
This, the judgment which you are referring to is only confined to 34(2) of the exercise.
I agree with her.
No, that is not.
What happened to this judgment?
Case.
What happened to this judgment? And the retained panel?
they have supplied the copy today.
And you got acquittal because the punch witnesses turned hostile.
My brother. So their whole genesis of crime is because of this incident, everything is right.
Some other person will not absolve you from looting the arms.
I agree, Miller. This is my brother's liquor. Now, brother's liquor, it was found to be legal.
Already, even if it's your brother's liquor, it is legal. You don't have a right to assault the police.
Miller, what do they have as of now? They say that I have assaulted my partner.
But where is the finding here that the incident itself is
No,
stopped?
please see, Miller, page 46 first. This is the evidence which they have taken, the High Court, the trial court has taken into consideration. para 17. The
This is not very important.
Yes, yes. And it says only one box was left with us. Those people had beaten us. The inspector sahib interrogated. Then para 18. Para 21, your lordship, para 21 onwards.
Yes.
So they say this is what one so and so was recovered from accused Ravindra Puri in para 21. Then para 22. And para 23. They say there was no mention about remaining 44 remaining quarter. The liquor bottle is called quarter. And para 24 in Caesar letter number so and so, no mention has been found about sealing of seize the goods, the case article number so and so, so and so.
There is a specific rule.
Any other
No antecedent. No antecedent.
This single factor dilutes your case. This claim that they came, they attacked, you were completely outnumbered, they got that Ravinder released, and then conveniently they only take 23 out of the 24 crates and leave one crate with you, so that you'll have something to show for the case. If they got 23 crates out, why would they leave that one crate for you? And then once you take that one crate also, you have no proper record of sealing it. The court also records that you admit to the fact that there's no proper panchnama, there's no proper sealing. So this crate seems to have conveniently come out of thin air when you needed to substantiate your case before this court.
In the present case, trial is going on. This is a connected case.
Very well, we won't make any comments on the merits of the matter, but anyhow, he's a senior citizen.
Reading other judgment in this case, I point out my case.
Keeping in mind the length of incarceration suffered by the appellant, the granted. Length of incarceration suffered by the appellant, and the fact that how many more witnesses to be examined?
Total 30 more witnesses.
14 more witnesses to be
33.
14 more. And the fact that the trial will not available to prove in the near future, but we are of the opinion that the appellant would be entitled to grant of relief at this stage. The appellant is accordingly directed to be released on bail in connection with FIR number so and so. Terms and conditions to be fixed by the trial court. He shall, however, cooperate with the trial and not seek any.
I'm so glad.
As per my instructions, out of 47 have been examined.
33 are to be examined.
Out of 47 have been examined.
So 37 have been examined.
Out of 47 have been examined.
So 33 more. I'm so glad.
Item number 10.
Waiting for the date in this. I see 2 weeks time to file counter affidavit.
And comes the hearing for respondent state seeks some time to file the
Returnable date.
that regard shall be done within 2 weeks or 3?
3
weeks. The joint letter, if any, may be filed within 1 week thereafter, based on 16th September.
Item number 11.
Lordships are being led by Mr. Paul is held up in 48, and these are early hearing applications.
Early hearing application.
So, Lordship, yes, because
Are
they're
you ready to argue the matter and keep it aside if you want?
Lordship may perhaps keep it next week. Mr. Paul's held up in 48. He's on his legs in fact.
We want to get up now.
Yes.
If you're willing, we'll pass it over, and when there's a possibility, we can take it up in the afternoon. If there's no other hearing matter, I think one we've kept aside.
May I suggest, Your Lordship, we get next week?
Record position. There's no other matter, so if we are free, we can take it
The
up.
issue really is the larger bench is going to decide the issue of quorum non.
There's a larger
That's the
bench.
issue. But so far
I
as
thought
the
the first item is the reference.
Please, my lord. That's the reference. Yes.
No, this one, the New India.
Yes, my lord. That's 11.
That should be heard by a larger bench.
3 judges. Sorry.
I don't want to interrupt.
No, but is it a 3-judge bench?
In this matter, that issue may not arise because the issue is whether one member can decide or not. They filed an application in these matters before the learned NCDRC that you can't hear, and then they gave it up.
No. In fact, there are 2 applications. With due respect, Your Lordship.
And number 2, I'm not showing it today. We can have it on some other. Secondly, in all matter,
they raised an objection and then waived it.
Recorded by the Honorable Tribunal.
Second, Your Lordship, with due respect, that's absolutely incorrect. Second, I appeared before the NCDRC Lordship. 2nd, 4/2024, we had moved an application under Regulation 12 saying that please constitute a member with a judicial member as well. The Honorable Court said that no, it has been heard long time and we will continue with the matter. The earlier council had already in 2023 had filed an application which still exists on the board and on the docket. So with due respect, that IA was not given up. What I gave up was Regulation 12 IA under the Consumer Protection Act.
I just place it on record. I have application of the order. Number 2, my lord, in all matters which your lordships are tagging with that question to be answered, my lord, your lordships have made the direction to deposit the amount. I have no problem. Please ask them to deposit the amount. With that matter.
100 crores, Your Lordship. 95 crores with interest. It's about close to 150 crores.
You are united India.
Your Lordship, may I just say this?
If you don't deposit it, will you be willing to pay the interest, whatever be the rate at which we direct you to pay?
Just have a look there.
If I can repeat.
1 second. Let me show, my lord.
Other matters of this nature, there's a deposit.
All matters, my lord, even your lordship decided one matter. All matters, they are kindly come to my lord first. Our document is at page 28. Yeah, please give him a copy. Page 28.
Page 37 also.
Yeah, and your lordship's order.
Yes.
That the entire money which was deposited here while the matter was remitted is sent back. Then, my lord, your lordship will see page 31.
31.
On the top.
Yes.
Subject to the deposit of my entire amount with 6% interest because that is what the decretal amount is.
This is also a similar matter.
And then, yes, similar, my lord, exactly similar. Then 32.
You can't ask for it.
Your lordship.
May I just say this, Your Lordship?
No, but if
principal
you
amount
yourself suffered an order of this nature in an identical matter,
I have.
Why should we take a different view only because the quantum is large?
And so far as Your Lordship's query whether we'll restitute him back subsequently in the event if I lose, yes, we will, Your Lordship. But may I only just say,
orders are there.
I know, I appreciate that.
Perhaps you would have made the same offer there also.
100 crores, Your Lordship, just the principal amount. May I just say 50%?
With 6% interest.
That will go up to 150 crores.
That's the short amount. I'm not getting some bounty.
150 crores and
in all these cases put together, it will come to 150.
Yes, close to. If I were to collect, calculate the interest at the rate of 6% from the date of filing of complaint, because what the NCDRC has done.
And the premium.
Once an order is there, then
No, I appreciate
why
that,
do
Your
you
Lordship.
deviate from that?
One can,
It can't be some kind of pick and choose, I mean, gamble or something like
The
that.
premium amount annually was 10 crore.
Lordship, 150 crore, can I just deposit just the 50% of the
No.
principal amount?
There's no question.
100 crores I'm out of pocket. In other matters also what my lord.
You're an insurance company, you're collecting premium, left, right and center, every claim you contest,
We,
right up to the Supreme
No,
Court.
we have a-
We asked another insurance company counsel, so we'll ask you also. Is there a single case where you honored your claim
A lot, Your Lordship.
without contest?
Claim-
Without contest, one case.
5 more in
Claim settlement
Not
ratio.
10,000, 20,000. Over 1 crore, have you settled even a single claim without contesting it right up to the Supreme Court?
There are
One
cases. We have paid survey assessors, we paid those amounts, Your Lordship.
We have not come across a single instance. The other counsel was fair enough to say that he may not be in a position to cite.
I have dealt with it, Your Lordship. We've offered, in fact.
You would not have dealt with it if there was no contest.
So,
Obviously it was
the assessment, we paid about.
If you dealt with it, obviously it was contested. Why would the lawyer come in otherwise?
For enhancement, they've come. We paid that, they've come up for
No.
enhancement.
They would have come up for enhancement if the claim amount is paid. So you are kind of contradicting yourself.
Either those international portals, where the ticketing agents are all over the world, this respondent is INDRANIL. And they have got this money where
Now, so this first item needs to go to a 3-judge bench.
Please, my lord.
Only because the IAs are listed before us, it's come before us.
I have no problem, but I'm
No,
saying that
we just need to have some clarity on that. The Levin is there?
before that, if your lordship will just permit.
Levin also was phone yesterday.
11,
Fine.
only IN.
Just show the file. Let us see whether there's an order.
Already, if your lordship will just permit me 1 more minute on this
No,
compilation.
not necessarily. We are inclined to pass the same order.
I'm not having any difficulty, but the application that I am giving up is placed on record with the order. That I'm giving up this objection.
That's what I'm saying. There were 2 objections. Sir.
I'm showing the document.
Are you aware of the order which referred the matter to a 3-judge?
Yes, my lord.
What is the date of the order?
It's page 40. Your lordship.
You filed it?
We've also filed.
Page 40 of?
The compilation of my learned seniors.
If for your lordship commissioner, please see page 40 of this compilation where that by referring the matter, order is quoted. If your lordship will just have a look at page 40 of this little compilation which I handed over.
Yes.
Your lordship will see the order, United versus INDRANIL in another matter.
I see it's already
the
been-
order is
very-
quoted.
Early applications have been filed by the United India Assurance Company for early hearing of its cases. However, we find that the late case pertaining to New India Assurance Company Limited has already been referred to the 3-judge bench. The 3-judge bench referred it to a larger bench.
No, Your Lordship. It came before Justice Suryakant was seized with the matter. And certainly thereafter it again got listed before His Lordship when he was sitting with Justice Khanna.
There are all matters which are referred, all those 5 which are mentioned in that order, all are referred to the larger.
That is Civil Appeal Number 3743 or 2022. Titles The New India Assurance Company Limited versus Messrs. ACT, this is page 41.
Yes.
ACT Private Limited, within brackets earlier known as Messrs. Citizens Care, within brackets India Private Limited.
And page 38, my lord, entire amount as awarded has been, my lord, your lordship order, page 38.
We however find that in matters of
Page 38,
identical nature, the United India Assurance Company, Insurance Company Limited was directed to deposit the entire amount
as awarded
under the orders of the LCDRC full form before the registry of this court, with along with 6% revenue.
Lord, in this it would be more. In that it was 6%. Here it was 6% within a time, thereafter within some more time, 8 and then.
For the time being left 6%.
6% from the date of complaints, Your Lordship may please consider from the date of complaints.
No.
Yeah, from the date of complaints.
From the.
That's
as
very-
directed, and as directed by, don't say as directed, 6% thereon from the date of the order of the judgment of the NCTRC. Within how much time? 4 weeks. Within 8 weeks. Within 8 weeks from today, the amount so deposited shall be invested in an interest-bearing fixed deposit in the National Bank with an auto renewal for a period of. What is the maximum interest? Is 6 months or?
Lord, let it be continuing, Your Lordship.
With an auto renewal clause, but
1 year, my Lord, 1
the
year.
maximum rate of interest is for a period of 1 year, is it?
6 months, I
No.
believe, Your Lordship. Auto renewal after 6 months.
For a period of 6 months with an auto renewal clause.
Lordship have said 6% from the date of the order.
6% from the date of the order of the NCBRC.
Great.
From the date of the
Yes.
date of the complaint, my Lord. That's all.
That is
Date of the complaint.
Grateful.
NCBRC would have granted from the date of the
Please let me speak.
date of the claim would be the
It was from the date of respective 1 month later the survey reports. Reports have
not from
come.
the date of the claim.
Your
No, no,
date
Your
of
Lordship.
report
The
is
date of survey report.
Survey report before the judgment. They are survey report which are the.
That would be earlier.
Yes,
Yeah,
date
that's
of
what
the complaint,
so-
my Lord, from which my date of
He's in fact
entitlement
giving
is.
you a better date. You want to pay it from the survey report.
6%, Your Lordship, may have from that.
6%.
Grateful, my Lord.
I'm great. The execution, they've initiated execution before the
So
end.
deposit, we will defer it within 2 months, we'll get it deferred.
No, it's coming up on second, so let them not.
Get it deferred.
We'll make
Just
the
get
second
it deposit.
There shall be stay of operation of the include.
Lord, only 6%, what you say as an interim measure because of our entitlement, we are able to.
6% as an interim measure.
Great.
With interest and payments.
Great.
Right.
Order for the larger bench.
Number 12. My lords may kindly see the office report. My lords had passed a detailed order.
You appeared on the last occasion.
Indeed, my lords.
You don't want your own money back. The suitors fund amount.
My lords, the money has to.
Suitors fund amount will go to you. You're paying the full amount due under the NCTRC order.
Yes, indeed, my
The
lords.
suitors fund amount is what you deposited when you filed the appeal.
My instructions are, my lords, that
You want to give that also to them.
because I have to pay him more, so it's okay. The money goes to him.
Why don't you pay him more? Are you not paying the full
No,
amount?
before the NCTRC, the amount that has accrued in the execution petition will be slightly more than what he's already got paid. So I would like to
This
know.
amount will also be.
So let it be.
This is about 1
How
lakh
much
plus
is-
interest.
That's very well.
We
Very
don't know
well.
how much still.
Very well. He would be fine with it, my lords.
So this amount also can be.
Can also go. Because there is a difference. I still have to pay him.
Very well. Miss Vanshaja Shukla,
Indeed.
General Counsel, attorney for the appellant in the civil appeals, fairly states that the suitor's fund amount of rupees 50,000 deposited in each of the appeals, along with the interest accrued thereon, may also be disbursed to the respondents in the said appeals, as the appellant would be required to pay some amount in excess of what would be paid to the respondents pursuant to the orders of this court. The registry is accordingly directed to disperse the suitor's fund amount or is 50,000 deposited in each of the appeals, along with the interest accrued thereon to the respondents, along with the amount directed to be dispersed
Which is 10.
pursuant to our earlier order dated 23/4/2025.
22/7.
23/4, isn't it?
7/7.
22/7.
22/7.
Oh, it's 22/7.
Well, for my,
Yes,
well, for my convenience, if I could know how much is 1 lakh plus interest,
no, the interest amount has not been quantified.
eventually, so it will help me in my calculations.
Oh, it's 1,05,000. 5,043.
No, that would be, my lords, 1 crore 5 lakhs 40.
Sorry, that's 1 crore is the,
on the
so they have
ground.
not indicated what the interest.
They haven't, but if they could, registry could kindly indicate, it will help me in my eventual calculations in the execution petition before NCDRC.
Dispersal of the actual amount shall be communicated to the council for the parties. So the registry
Again,
will come.
right, very well.
There is also the principal amount interest, right? Principal interest.
That already the order is there.
Accrued with principal interest will be there.
Which one?
In the office report, para. This one.
This one also.
Only the principal amount.
No, it isn't.
We have directed for the principal amount, not interest to there.
Oh, there's no mention of the
Yes,
interest. The interest accrued on the principal amount of rupees 1 crore 5,43,332 shall also be disbursed to the respondents jointly under due and proper acknowledgement.
And now, my lords, can clarify that the total amount disbursed should be notified to me.
And after that, you say the total
Total.
amount disbursed by the registry to the respondents shall be intimated to the learned council for the error.
Deeply grateful, my lords, deeply grateful.
Item number 13.
So you are running your petrol pump, you don't want any other petrol pump?
No, my lord, the High Court has actually recorded incorrect finding, my lord. Neither I am running, nor the other side is running.
Why you are not running?
No, my lord, what had happened, my lord, in this matter?
Your petrol pump is there or not?
No, my lord, not there, my lord.
Still not
Not there, my lord. What had happened in this matter? Yes, my lord. I have not started. He has also not started at Japi.
Now, this document which you filed
Yes, my
yesterday,
lord. Yes, my lord.
the National Highways Authority's letter.
Yes, my lord. They have
says that
objected.
your retail outlet is in violation of the norms.
No, my lord. There.
Page 5.
Page 5, my lord. There. Not mine, my lord. There 5. Actually, this is case of recitement, my lord. He want to shift from Kanpur to Jhansi. At Kanpur, he is running at presently, my lord.
No, your retail outlet is of which company? HPCL.
IOC, my lord. Indian
Not
Oil
IOC.
Corporation. And my lord, guideline is there, and the High Court has dismissed my.
Are you running a retail outlet or not?
No, I'm not running, my lord. Neither he is running at Jhansi, my lord.
So how you can stop the HPCL from opening a retail outlet?
Yes, my lord. My lord, I am not objecting, my lord. I am not objecting. There is a specific guideline in what circumstances he can shift from one place to another place. Where already I have been given a chance to.
They can do it. They can do it.
So within those norms, they have to do it.
Yes, page 73, the High Court has said, my lord, in writ petition. I have stated everything in writ petition. So my representation is pending. Despite that, my lord, the company is going ahead, my lord. And representation has not been decided.
This letter which you have filed.
Yes, my lord.
At page 5.
Yes, my lord.
That indicates that they would not be in a position to recite now. The
My lord,
NHAI
this is the correct position, my lord. Despite all these things, they are going ahead.
How will they go ahead when the NHAI has
My
said
lord,
this?
that is why I am telling you, lord. Just see 2 letters, my lord. 2 letters, which we have challenged before the High Court. Page 35, my lord. Actually, this is, according to us, this is case of a fraud. The person who is running at Kanpur is Daulat Ram. And he is.
After this NHAI letter, has the NHAI again said that you are permitted to recite now?
No, my lord. He has been permitted to recite and go ahead. That's why.
Letter shows that the recitement proposal was
This
rejected.
is the NHAI objection, my lord. This is the NHAI objections.
What
But, my lord, this is objection raised by the National Highway Authority of India, my lord.
Very well.
And the company, your lordship, just see 2 objections raised by us.
After this, what happened?
After this, my lord. My lord, they have been given time to remove this objection, my lord.
There is a question of removing it.
Next page, your lordship, just see next page.
Distances.
The lordship, just see next page, my lord. And on the spot investigation, may I read, my lord?
You know how retail outlets is commissioned?
Yes, my lord.
You know the process?
Yes, my lord. Lordship, just see page 42,
The petroleum rules, the
Yes.
collector grants a license, explosive license.
Yes, my lord.
And it is NOC of National Highway Authority of India is required.
Yes, my
So
lord.
it is the collector who looks into everything.
Correct, my lord.
So once there are violations, then look into it. There is a question.
That's why we are saying, my lord, at this stage, and we have requested the Honorable High Court that my representation should be decided. Everything will be clear, my lord, from that. Because your lordship will just see there is.
It is not sitting there to direct.
No, my lord, since the High Court has.
Listen to your representative.
My lord, the High Court has been wrong, my lord.
If the explosive license is granted contrary to rules, you are free to challenge it.
My lord, that's why I challenge, my lord.
That's the explosive license.
Yes, your lordship.
Commissioning order.
My lord, that has not been granted yet. That is not granted yet, my lord.
The authorities from passing an order.
Then your lordship may grant me liberty, my lord. Your lordship may grant me liberty.
If anything happens contrary to the norms, then you have a cause of action.
My lord,
You are only anticipating that they will do something.
your lordship may just see page 35. Page 35.
And
the letter
the letter that you have now filed shows that the NHAI is aware of what is
before
happening there. They have objected to the recitement. What more remains?
My lord, page 35, your lordship may just see.
35.
35 of the assembly paper, my lord. Annexure P7.
What is this?
My lord, your lordship may see is restructuring of dealership, my lord.
This is the company also would have to abide by what the NHAI says. There's no question of the company violating the norms.
What I am submitting with great respect, my lord, that we have raised various objections in our
Project followed it. You want to establish your retail outlet, IOCL. You don't want HPCL retail outlet to come up. That's the only point.
No, my lord.
So the complaint authority is the district magistrate. The district magistrate will look into all reports, all NOCs, and then he will grant the explosive license.
That's why.
No, unless so in case a license is granted contrary to the petroleum rules, then you have a case. Otherwise, no. Let the exercise be done.
Only but two rules I want to show you, lordship, my lord. Not
please show it to
this stage. Nothing is.
two rules I want to show. Two rules I want to show, my lord.
The material placed on record.
Then your lordship will permit me to withdraw it, my lord.
We argued for some time.
To take appropriate remedy available under law, my lord.
6. Permission to withdraw the special leave petition, preserving liberty to the petitioner to seek redressal of her grievance as and when a cause of action actually arises.
Highly well, my lord. Highly well.
Special leave petition accordingly dismissed as withdrawn with the liberty of the state.
Highly well.
Item 40.
Lordship, in item number 14, I have moved an adjournment later on the last.
File a status report with regard to how the investigation is.
Yes, Your Lordship. On the previous occasion, Your Lordships had directed me to file the status report.
That is so. That was in June.
Yes, Your Lordship. Your Lordship, I have received the instructions. Your Lordship, I have received the affidavit. Your Lordship, may kindly give me 1 or 2 weeks. I will do the needful.
Also, case also this kind of carelessness, what is to be done? Police authorities have absolutely no sensitivities.
Lordship,
the complainant, the victim herself files a complaint, and you just brush it aside, say that the accused is 14 years old, so it is all right.
Your Lordship, the FIR has been subsequently registered, Your Lordship, with regards to the merits of
how much later? Incident of?
And how state has started defending criminals?
Lordship, at this stage, I am just asking
No.
for some time to bring the
If they are aggrieved, they should file a writ petition. How the state is defending accused persons? This is too much.
Your Lordship,
Nothing to
state is defending.
So the earlier order seems to have let off the ASP and the SSP.
If they are aggrieved, let them come.
Your Lordship, I have received the affidavit last time.
Very
They have
sorry.
filed the affidavit.
Dismissed.
Your Lordship, may kindly pass it.
No pass over.
It will come on my head, Your Lordship, because of the nature of the matter.
We will give you 1 week time.
Enough to.
Your Lordship, I understand, but
We will
Your
give
Lordship,
you a week's time. Please file your status
Very
report. And in fact, you can also tell your ASP and SSP that the interim protection extended by the earlier bench, we may not be inclined to extend it to them. In spite of receiving a letter from the mother of the victim, your ASP does nothing, your SSP does nothing. What is it doing?
The state is defending them.
SHO does
I
nothing.
don't have the liberty
And they are
to
also
make
doing the
comments
same
on that
thing.
regard. At this stage, Your Lordship, I will just file the status report and I will take appropriate action.
But we are putting you on
Yes, sir.
notice that don't rest assured that the earlier protection is going to continue. They are also both in the dock merely because they are of a higher rank, they're not going to be let off. They should be held more responsible. Because the SHO in all probability would have been acting at the behest of what the SSP and the ASP said. He doesn't act independently. SHO dance to the tunes of the higher officer.
Lordship, subject to satisfying your Lordship, on the next day, there were measures taken by the ASP as well.
Nothing. 23 complaint, April 25, after perhaps when was this SLP filed? After the SLP is filed, perhaps then you register the FIR.
Your Lordship, it was
not even during the pendency of the writ petition.
Deeply.
And counsel for this status is granted 2 weeks time to file his status report in terms of the earlier.
The order is not over, don't leave.
Dated 27/6/2025. List on. Second suspend. These are not taught by your senior.
As
that when the order is being.
Lordship, actually, I just missed it.
No, you wanted to leave as early as possible.
Yes, sir. That was exactly the situation. And I'm apologetic.
We need not be scolded. We have to scold the seniors. We're not grooming the juniors properly. They're not told what to say in court, how to conduct themselves.
Your Lordship, he's doing a fabulous job. It's my mistake. I admit on that point.
You want to still protect your senior. That is at least laudable. Very well. Go. Yes, Mr. Grant.
Now this comes for disposal. And I just give your Lordships an outline of what the issue is.
Yes.
For the immediate.
Who's opposing you?
Immediate trigger, I will give a list of dates also, so your Lordships may rest assured. Yes, I'll give the list. Just give me 2 minutes, I'll give the list. Or just by way of background, 2 or 3 things before I give the list of it. One of the immediate trigger for this matter was that the respondent filed a commercial suit in the Delhi High Court. We filed an application, GIAG is a Swiss-based company. We filed an application under section 45 for stay. That's the background. Before I give the list of dates, just 2 things further I want to mention. First is that under 45, the reference is mandatory and the standard is only prima facie. I only have to satisfy a prima facie test that there exists an arbitration agreement. I'll come to the law later, because I think that's a. In fact, now the act has been amended to bring in the words prima facie. There's a history to that. I'll come to that later.
You want us to look at the provision first?
No, not the words prima facie.
It has
been brought in 2019 pursuant to the Sri Krishna report. In fact, there's a history because Justice Sri Krishna.
Yes.
Justice Sri Krishna actually wrote the judgment. There's an interesting history, just a slight diversion.
Yeah.
Justice Sri Krishna wrote a judgment in Shinetsu. I'll paste Shinetsu, where he propounded the prima facie test.
Started from Madhya Pradesh.
From
Rewa.
From Rewa.
Civil judge granted injunction in international arbitration.
Correct. So, Justice Sri Krishna said prima facie case. Justice Sabharwal said full trial. Justice Dharmadhikari agreed with Justice Sri Krishna, and therefore, when this committee of 2019 came, where he was the chair of the 2019 committee, he said it should be put in the act. That's the background. So, this is one aspect. One of the second aspect I want to make is that we argued a case in the alternative. Moment your Lordship, no one argues a case in the alternative, there is always some confusion. So I am not first arguing the primary case. The judgment, the problem that we face with the judgment is both the primary and the alternative case have been elided. I want to show what is our primary case. Please see volume 2 first. Volume 2.
Yes.
The first annexure is my application. And please come now to page 251. This is my application, which is the basis of this proceedings.
Yes.
bottom of 251, I just showed 2 or 3 pages, and that is my primary case. Plaintiff accepted the benefit of the 2016 contract by receiving delivery of materials in terms of 2016 contract. Plaintiff also furnished letters of credit and standby letters of credit in terms of the 2016 contract to secure the payment of the materials. Undoubtedly, parties have acted in terms and in accordance with the 20 as such are bound. Thereafter, my lord, at 32, we say there's an arbitration clause in the 2016 contract, and 32.2, and therefore, my lord, we have sought reference. And then 253, your lordship will see. Again, we mentioned the relevant provisions,
Yes.
and that is, my lord, our basic case. Their defense effectively is at 254, paragraph 39. Submitted plaintiff in the instant suit sought to wriggle out of the 2016 contract by saying that it was not signed. The fact that the parties have acted in accordance with terms clearly established. So this is how. Primary case, our alternative case is at 255, which has caused the confusion. We say that there was an older contract of 2012 that has a clause which is incorporated by reference. Please keep that aside, because most of the judgments in the include order are on the alternative. But with that background, may I just give the list of them? Coffee.
Yes.
Right.
Yes.
What should we just give me one second? It's fine. My lord, the first 4 dates are the prior 4 agreements. Please only note that each of these 4 agreements has a specific contract number. So, my lord, for instance, the first one has contract number 61 year 11 13 375S, and it is for the supply of 400 metric ton, and my lord, it has an arbitration clause at page 75. Just by way of example, if your lordship wants to look at one of them, kindly first see page 54. Volume 1.
Yes.
Just as an example, Lord, it has the contract number.
Yes, at the top.
It has the contract number. It has the date, and my lord, at page 75, there is a clause 28.1, which is got the contract clause. This has been repeated, my lord, in the others in slightly different way. This contract, including the arbitration clause, is laws of England, and 28.2, my lord, is at page 75, 76. It is going under the LCIA, and it goes to C3 London. So, my lord, this was the pattern which was being followed. I don't want to show all the agreements. 1, 2, 3, and 4 are the prior 4 agreements. They all have a specific contract number. They all have a specific arbitration clause of English law, etc., etc. Not only one point I want to mention, in fairness to the other side, all 4 were signed by both parties. This is, my lord, the position. Now, my lord, I leave 11/1/2012 for a moment because that is the previous contract. That's my alternative case. Now, your lordships will bunch together items 5, 6, 7, and 8 of the list. This is now, we are in the year 2016. 5, 6, 7, and 8 consists of an exchange of emails. I have set them out. Lord, I think it is better if I show them from the actual volume. Please see volume 3. Annexure P32.
Page
397.
Yes.
All the pages are mentioned in the list of dates also. Well, the first email is the one at the bottom. The last line on page 397.
Yes.
On 26/3/10 to 22/17, Amit Srivastava, Glencore.com Road. So that's the first email. It starts at 398, dear Mr. Agarwal. Further to our discussions in your below email, please following are the final terms at which GIAG, which is the Swiss company, can offer zinc metal to Ganesh. This is the, so various terms are there. Only term I would like your lordships, two terms I would like your lordships look at is at page 399.
Yes.
Well, somewhere in the middle, little difficult, not somewhere in the middle, there is a paragraph beginning payment in US dollars.
Yes.
Please see the fourth line. Provisional price shall be LME average of 10 market days prior. Just mark it, it will have some relevance. And then below the bottom of the page.
What does LME stand for?
London Metal Exchange. Well, we are metal traders, we buy and sell zinc. So we price it at the LME price in London. That was in fact the merits. Then last page, last term there, all other terms and conditions as per last contract between GIAG and Ganesh. And then on the next page, kindly confirm validity. So this was the first email. In response to this email, if your lordships are pleased to go back to page 397. So one email is
this was basically an offer.
This was an offer, correct?
Yes, 397.
39. Number 397 is this reply email is dear Amit. It's in the middle of the page. We confirm the same terms as said. Just one thing, that provisional price of both either LC or invoice will be average of last 5 LMEs. For March so-and-so dispatches, we provide you LCs between so-and-so for so-and-so dispatch receipt, etc., preferably from Malaysia, etc. Then he replied, Mr. Sanjay Agarwal replies. And he says everything is okay except this one issue. Then we respond to this at the top of the page. Thanks for the business confirmation, reverting to the contract and perform. Now, it is our case that on the basis of this, we then sent them a formal contract. Now, so far as the formal contract is concerned, we have put in a typed copy. But interestingly, the original of the contract is with them. This is the admitted position. They have filed it in the Delhi High Court. We've got photocopies of the document filed by them. Because they had also. It's there on record, the typed copy, but I think it's maybe more appropriate. So this was the document which was sent to them. Please first note the contract number, because much will turn on this.
Photocopy,
This is a copy, actually it's a copy taken, soft copy taken from.
Neither party signed it.
No, we signed it. They did. The signature is there. Every page, it's there.
Page 80 there.
Every page is there. We signed it. They did not sign it. If your lordship sees page 80.
80.
Now, some clauses of this I just want to show to my lord. First, please see the contract number at the top. This will have some relevance. Then the Lord may see, clause 8 is the price. There are various other clauses on price. 11.2.
Yes.
Lord, 11.2 provisional payment. The paragraph reads, 100%, etc. Then just below that, the provisional value of the material per metric ton shall be official LME cash settlement price as published in the London Metal Bulletin, averaged over 5 consecutive.
As suggested
by them. Then 12 is important. In terms of this, they will have to give what is called a standby letter of credit. In fact, the suit concerns 2 standby letters of credit, which we say are given in terms of this, which we encash. That's really the fight. So 12.1 is the standby letter of credit. And then after that, straight away 32 is there, which is at page 80, which has the contract including the arbitration governed in English law, seat in London, LCIA, etc. So we say, 32 applies. That's our case. We have pleaded that.
How is this arbitration clause different from the arbitration clause in the earlier agreement?
There is a slight difference. The earlier agreement, did not would your lordship like to have a look at that?
Yes, that
kindly
the High Court notes.
Yes, High Court note. Kindly see 152 and keep this open also.
152.
152. My lord is right, but my lord, again, that is a matter to do with the alternative case. That's the problem, my lord. My lord, the difference.
Alternative case being you are falling back on the 2012.
Yes, yes. Otherwise, my lord, this is the entire judgment proceeds on mainly on that. This is the previous clause. The difference here is, my lord, that there is one extra sentence at the end, which says in the present contract, number of arbitrators shall be 3. Otherwise, my lord, it is broadly similar. And 153 earlier there was a waiver of right of appeal.
Please waive
that sentence is not there.
That sentence is not there
because, my lord,
and the number of arbitrators was not there in the earlier.
But that follows, in fact, actually there is no discrepancy because it follows from the rules. But I don't want to get into that, but that is, my lord, what the High Court has noticed. So, my lord, my submission, our submission is very simple. There is a contract between the parties. The contract, and I only have to show prima facie case. The contract between the parties was in writing, number 1. 2, it was acted upon by the parties. 3,
only by issuance of the standby letters of credit or any other acts?
Lots of acts.
What are the other acts?
4 things. 1, 2,000 metric tons out of 6,000 metric tons delivered.
To them.
Taken.
2,000 metric tons.
2, 8 invoices raised by
2,000 out of 6,000.
6,000. Admitted.
Then
8 invoices raised by me under this with the contract number and various, my lord, details.
That's been honored. Your invoices have been not paid.
No.
Raised, not received by them and not protest.
No protest. Received, no protest. Receipt is not disputed. It was filed by them in their suit. There is no dispute of this. 3, 2 standby letters of credit issued by HDFC Bank specifically referring to this contract, this date, and amended to bring it in line with this contract. Not even just a casual reference, because your lord.
What do you mean amended?
My lord, there was a discrepancy in the letter of credit. They got the date wrong.
What date?
The date of the agreement.
The contract.
Of the contract was, as your lordship notes, 11th of March. They put in some other date. The other side went, got it corrected and amended and told us that. And that also I will show, not noticed by the High Court. 3rd and 4th, my lord, there is a course of 7 or 8 letters where I will show, my lords, that they have actually mentioned various obligations, substantive obligations. And 5thly, my lord, the entire suit, which is the subject matter of, my lord, stay, is in respect of 2 letters of credit. Lord, this is my case.
Entire suit is about those 2 letters.
2 letters of credit and some damages claim. And can only be on the basis of the contract. Now, my lord, to meet this case, in the counter affidavit, the argument is that there is an oral agreement, different from what the plain, but that is the argument. There is an oral agreement. And the second argument is, and I'll show those pages, that this number of the contract was only quote unquote a nomenclature. This is their defense. So your lordships have to now decide whether prima facie I have made out a case for this clause. This is the short point, and I'll then place the judgment. And my lord,
These letters of standby credit, they also mention the contracts.
yes, of course. So I will go one by one. First, the invoices, which is at item 9 in your list of your lordship. Well, on first point I mentioned that they lifted 2,000 metric tons. This is part of their plaint at page 220.
Page
220. No? This is their plaint which they had filed, the suit which they had filed, which it starts at 209. And at 220, paragraph 8, last sentence, they admit to lifting 200 metric tons, 2,000 metric tons. Now, the earlier agreements were of much smaller amount.
And according to them, they did it out of the oral agreement.
That is now what they say in the counter.
So in the plaint, what did they say?
Sorry?
In the plaint, what did they say?
In the plaint, my lord, I think my learned friend will have to explain what his case.
Not explain on what
not
basis.
clear on what basis he is saying that there is a contract. But I just want to show not the portions 220. Well, not for an oral contract, you have to plead who are the parties, when did it happen, where did it happen, what are the terms, etc. None of that is there. So, this is para 8. This is one point. Point 2, my lord, is in respect of 8 invoices raised by us, which is at page 9. There's item 9 of the list of dates. My lord, we just see the same volume, just illustratively, 165.
165.
Just by way of example, only 8 of them.
So this is part of the 2,000 metric tons which they had lifted.
Yes, yes. This is 165 is one example. Glencore International, and we give the contract number, we give the zinc metal, we give the ship on board. Contract number 061.16.12115S. Your lordship will see right at the top. And my lord, there are payment is by LC, and this is raised from Switzerland. There are 8 such documents. I will not trouble your lordship. They have all been filed with their suit also. So they
filed your invoices also along with this.
They, sir. Well, in fact, what I've done is I've taken a printout of the index filed in the suit. Just, my lord, for the purpose of. So this is how it was filed in the Delhi High Court. Now, the first 1, 2, 3, 4 are the earlier agreements,
2011,
right? And here they say original is in my custody and photocopy is in there. But in 5, my lord, they say original is in custody of the defendant. Because, my lord, we had sent it, they had not signed it and sent it back. And then, my lord, 6. And then 7 onwards are all the invoices which have been mentioned.
Yeah.
So that's the second issue. But before I go to the correspondence, let me show you lordship the 2 letters of credit. Please first see before that the prayer in the suit. But there is some discrepancy in the prayer in the suit as filed by me and as filed by them. So I am going to go with the version filed by them. I don't want any one second. In the suit filed by them, I'll show some paragraphs later, but I want to show what this is the counter act. The prayer in the suit is at 505 in the counter act.
Yes.
Pass a decree for recovery of so and so clause in favor. This is on account of price fluctuation which they are claiming. Pass a decree in declaration against the defendant declaring purported invocation bank guarantee dated so and so and so and so. My lord, please note the two dates of the bank guarantees are illegal, are not entitled to invoke, and my lord, bank guarantee is void. And this last sentence, my lord, somehow we don't have in our copy of the claim. But I don't think, my lord, it has it detracts from the argument. So, my lord,
which is the last sentence that you don't have?
And further declare that the plaintiff has the right to fix the price of entire assets.
And see that part of it
is on the contract. That portion, for some reason, is not there in the copy that we have, which we have been served. But be that. So, these are the two bank guarantees which in fact we encashed. This suit was filed perhaps to stop the encashment, but by the time the suit was filed in February 2017, the contract was entered into March 16. The suit is filed in February 17. So there is a long course of conduct till February, and then in March we encashed the bank guarantee. February we encashed the bank guarantee. So we see these two SLBCs.
But the prayer reads to the effect that you've already encashed it, they're seeking recovery.
Yes. Yes.
So
yes.
When was the actual encashment?
2-3 days before this.
Before the finding of this.
Before. After the last letter that we issued. But we just see those two SLBCs because much will turn on that. Please come to volume 3. P34.
Page
439. This document is the initial guarantee which is dated 22nd Please come first to 442, bro. That's the second one. I'm showing the first one. 442.
Yes.
Well, not 442, your lordship sees first.
Yeah.
This is a the document which is dated 22nd April 2016.
Yeah.
Now, in this document, your lordship will see item 45A and 46A. I want to read 45A. Zinc metal so and so, contract so and so. As per contract number, please see the number. This is the same number.
Yes.
Dated 12th April 16. Now, Lord, I had mentioned it should be 11th March, but this is showing 12th April. And similarly, documents required to be encashing the bank guarantee, unpaid invoices, transport documents, statement by me, confirming that the applicant has failed to fulfill his contractual payment obligation and contract number, so on. Now, my lord, because there was a discrepancy here, this is 22nd April, well, what happened was that the Other side approached the bank and asked for an amendment by an email of 2nd of July. Please keep that also open if possible. That is at page 175 in volume 1. This is on 2nd of July, it's in the list of dates. Sent to us. Dear ma'am, I have to go to hospital due to some injury. Friend, I could attend your call. HDFC Bank, impossible to understand. Like the process being completed, amendment done. Finally, got copy. We share it below. Sorry for delay. All on our bank. So this email, and then at the bottom is the amendment by the bank of 2nd of July. A clearer copy of this, I can show it from here. A clearer copy of this is at page 444 in the previous one. Four 79 other amendments. This is your lordship sees date of LC 22nd April, date of amendment 2nd July. I identify and preceding amendment. Field 45A now to read as zinc metal as per covering applicant's contractual obligations under contract number so and so dated 11th March.
This is the last contract. Last contract.
This is the contract in question. 2016. Similarly, 46 is even more damning. Point 1, how to read. Applicant has failed to fulfill contractual obligations. Import contractual obligation, contract number so and so dated 11th March. Field 46A, again, same sentence repeated for again with the same
contract number 11.
So, now to say with this overwhelming material that I have not even made out a prima facie case that there is a contract between us on only the basis that I have not signed it would be perhaps more. SLBCs which were second one, there is contract number is mentioned. There's a discrepancy regarding the date, but the contract number is mentioned. That your lordships will see at page 440. It starts at 439. This is the second document. 45A.
Yes.
Again, the contract number is mentioned that 12th April error has crept. And then 3, statement issued by the beneficiary confirming the applicant has failed to fulfill a contractual payment under contract number so. So these are the 2 SLBCs. I will just conclude this by showing the correspondence very, very briefly. Let me come back to the list of dates. Item 11 to 17 in the list of dates is what happens between July 16 and February 17 when I encash the bank.
Yes.
All my letters expressly refer. Their letters responding, I also want to show. Now, let me just keep volume 1. Just a few pages. Well, let me come to 181. $181 volume.
Yes.
Well, this shows what we have written: reference, non-performance contract number so and so, reference, subject contract. Then, at 181, we mentioned clause 11.1, we mentioned quotas, etc. And we mentioned letters of credit, and we say that you have not done the necessary. But their reply is at page 185. At 185, 2/3 down the page, right at the bottom. Subject re-FW contract number so and so for sale of 6,000 metric tons. Importance high. 186B is there. We in no way going to default anywhere in the contract. Lord, the third letter is at 194. That's again our letter.
I'm sorry, which page number?
194.
Yes.
Again, my lord, we say that you have not paid.
Same contract number.
Same contract. 197. Their reply.
And
conditions of service of
persons
persons
serving
the union
number
or a
of
state.
factors,
Subject to the provisions of this constitution,
PC 198,
acts of the appropriate legislature
paragraph
may
2.
regulate the recruitment
Secondly,
and
as per
conditions
the agreement, you
of
can
service of
50,000
persons
SLBC
appointed.
per month.
No
This is
public
directly,
services imposed in
clause
connection with the affairs
12.1
of the
which
union
talks about
or
this
of any
agreement.
state,
And my lord, you are
provided that
writing
it
wrong
shall be
amounts. We
competent
have
for the president
financial
or
issues,
such
etc.,
persons as he may direct
and the
in the
conclusion
case of
of the
services and posts in connection with the affairs of the union, and for the governor of a state or such person as he may direct in the case of services or posts in connection with the affairs of the state, to make rules regulating the recruitment and conditions of service of persons appointed to such services and posts until provision in this behalf is made by or under any act of the appropriate legislature under this article, and any rules so made shall have effect subject to the provisions of any such act. So this is our source of power. Now, if we may just place a few of those rules. If your lordship goes to page 126.
Yes.
The opening words, in exercise of the power conferred by the proviso to Article 309 of the Constitution, the governor is pleased hereby to make the following rules. These rules may be called the West Bengal Services Revision of Pay and Allowance Rules 2009. They shall be deemed to have come into force on the first day of January 2006. Save as otherwise provided by or under these rules, the rules shall apply to persons appointed to civil services and posts under the rule-making control of the Government of West Bengal, except members of the All India Services, the West Bengal Judicial Service, and the members of the service to whom the University Grants Commission and the All India Council of Technical Education scales of pay apply. And then unless specifically extended under express order of the government, these rules shall not apply to so-and-so. Now, if your lordship is pleased to go to Rule 3, definitions. In these rules, unless the context otherwise requires, your lordship has that. Now, please go to 3C. Now, below 3C, your lordship will find that there is a slight typing error because immediately below that is Roman 2. So may I just request you to change it to 1, 2, and 3 instead of 2, 3, and 4.
Okay.
Now, existing emoluments mean the aggregate of 1, existing basic pay, 2, dearness pay appropriate to the basic pay, and 3, dearness allowance appropriate to the basic pay plus dearness allowance pay at index average 536 with 1982 equals 100. Now, this is what our rules provide. The rule does not, this is the manner in which it is framed. I will just take you to one or two other rules. But there is no concept. So there is a scale. It's specified the exact manner in which this particular dearness allowance is to be computed. It has to be appropriate to the basic pay and appropriate to the basic pay plus dearness pay at an index average 536 of 1982 equals 100. Now, we follow this strictly and down to the T. The tribunal, as your lordship has now seen, requests us to revise, revisit, come up with something new. The rules are clear. There's no fault found with these rules at all. Where is the question? As and when the government considers it appropriate to amend these particular rules, they have a constitutional sanction which I placed before the court. If there's something wrong with these rules, it has to be struck down. But it cannot and ought not to be where you have a direction, which your lordship will recall. I'll use the exact phraseology. The respondent number 1 chief secretary is directed to evolve norms and principles within a period of 3 years, 3 months from the date of this order for release of DA on the basic pay of state government employees fixed in terms of ROPA by taking into consideration inflation on the basis of the AICPI number. Page 489. Yeah.
What is your colleague's name? What is her
Your lordship has page, just go to page 488, volume 2.
What is her name?
Mahima.
Very vigilant. Thank you. Yes.
But just go back for a moment. We keep this, we'll stick with the rule, but just go to page 488 for a moment.
Yes, we have it.
See the observation in para 37. The upshot of our observations is, 5th line. The upshot of our observation is that the state government employees are entitled to get DA on the basic pay fixed in terms of ROPA rules 2009. Now this is the flourish. At a rate to be calculated on the basis of the AICPI number published from time to time till the date of giving effect to the 6th pay commission set up by the government of West India. So this is the problem, published from time to time till the date of giving effect to the recommendation. Where do they get this from? Published from time to time. So there's a continuous sliding scale according to an obligation to keep amending the base. We are following the rules strictly. We are required to follow the rules strictly. But there is no question
Fix it back to rules.
Nice.
Those are the dates which I indicated to the court.
2008 to 2019.
Yes, 1st April 2008 to 31st December 2019.
If not AICPI,
Yeah.
what is the basis of your calculation?
Sorry?
What is the basis of your calculation? If not AICPI?
It's exactly this. Exactly.
Tell us what is your basis of calculation of DA?
Yes.
From time to time.
Yeah, it is, Manoj, as we take the base figure, if your lordship sees C, 3C, 3. Your lordship has 3C3. You have corrected 3C3, Manoj, at page 127.
127.
Yes. ROPA rules, Manoj.
Yes.
We have to follow our rules.
Yes. No, 3C3.
Yes, that's the base figure which is indexed and fixed.
It only defines the DNS allowance and DNS pay and
Correct.
DNS allowance.
Correct. So I'll just answer the
What's
question.
a DNS allowance appropriate to the basic pay plus DNS pay at index average 536?
Correct. So I'll just explain. And then we.
And your percentage is fixed on this base.
Correct. Absolutely right.
That is what you say.
Absolutely right. So I have the statutory base is prescribed under the rules. I follow the statutory base fixed under the rules, and thereafter I have memorandums, government orders and memorandums issued from time to time, which increase the percentage on this base. So we will see that. We see that how it that's how it progresses. But these are the rules. Now please see the expression existing emoluments. So there is a concept of the existing emoluments, and then there is a concept of DNS allowance, which is indexed on the basis of the existing. Now see the existing emoluments, very, very clear, means the aggregate of existing basic pay, DNS pay appropriate to the basic pay, and DNS allowance appropriate to the basic pay, plus DNS pay at index average 536. 1982 equals 100.
Where is this geo?
Yes, so there is a series of geos which we will come to once I place the rules. But to give you an example.
When it was released,
so from
2% for the first time.
Yes. So
after ROPA 2009.
Yeah.
Give us that geo.
Yes. So many of them are on record, so I'll just answer that.
1692 of 23rd February 2009. Give us that geo.
Okay, so we just go to page 162.
162,
same paper book. I believe this is what your lordship is asking for.
Yeah, so that we understand your basis of release of GA and the AICPI basis. Yes.
Yeah, I'll just place that. I think what the court is putting is very pertinent. Your lordship has 162?
Yes.
So just note this. This is one of the
first one, 23rd February 2009.
Sorry, yes, 23rd February 2009. May I place this before you, and then I'll come back to the rules.
Yes.
I'll go back to the rules.
Yes.
So just see this subject: clarificatory memorandum of the West Bengal Services Revision of Pay and Allowance Rules 2009, and on allied matters dealt with by the 5th Pay Commission. In Finance Resolution dated 28 August 2008, the government constituted a pay commission, and then the remit of the pay commission is indicated. Para 2 deals with scales of pay. Paragraph 3 deals with fixation of pay in the revised pay structure. Now there is a specific paragraph, which is paragraph 10, relating to DNS allowance. And may I take you there? It's at page 166.
Yes.
Your lordships have 166.
Yes.
So I'll just place this. Consequent upon revision of pay of government employees in accordance with the West Bengal Services Revision of Pay and Allowance Rules 2009, the DNS allowance to which government employees is entitled from time to time since the first day of January 2006 needs to be related to pay in revised pay structure. Necessary government order in this regard has been issued with Finance Department memo dated 23rd February 2009. And that your lordship will find at page 168. Could I just take you 2 pages further? Please see last para 3. There's actually in para 2, there's a reference to Rule 12 of the West Bengal Services Rules 2009 that no arrears of pay and allowance to which any government employee may be entitled in respect of the period so and so to so and so shall be paid to the government employee. The dearness allowance admissible to a government employee needs to be related to his pay in the revised pay structure with effect from 1st April 2008 only. Accordingly, the Governor is pleased to decide that the dearness allowance payable to government employees with effect from 1st April 2008 shall be as follows. So from 1st April to 31st May 2008, rate of dearness allowance per month on basic pay is 2%. Then for the next period, June to October, 6%. 1st November 2008 to 28th February 2009, 9%. 1st March to 31st March 2009, 12%. And 1st April 2009 onwards, 16%. On the basic pay, rate of dearness allowance per month on basic pay. Then overleave, the payment of dearness allowance under this order from the dates indicated above shall be made after, sorry.
They were not getting any dearness pay at that time.
Earlier they were getting, but that's under a different set of rules, earlier rules.
No. Under the ROPA,
our rules come in 2009.
3C4.
Actually, it's 3C3. Because I requested you to just make that correction.
Okay, 3 or 4.
Anyway,
yeah, that's right.
Later, 3C3.
Yeah.
Dearness allowance appropriate to the basic pay plus dearness pay.
Yeah.
It is plus dearness pay.
Yeah.
Basic pay plus dearness pay.
Yeah.
At index average.
So 536.
So in this para 3 of page 168, dearness pay is not mentioned. Only basic pay is mentioned. What is this difference?
Yeah. So Manoj, the earliest dearness pay gets merged with the basic pay. For the starting point.
At the time of revision, it merges.
Yes. So that's why the concept is very clear.
Yes.
Dearness allowance appropriate to the basic pay plus dearness pay at the index average of 536.
No.
So that merges for the earlier period.
When revision takes place, the dearness allowance or dearness pay merges with the basic pay.
That's right.
Then what is the need of mentioning in dearness allowance 3C3 appropriate to the basic pay plus dearness pay? If it is already merged.
No, it will just see, it says existing emoluments means the aggregate of existing basic pay. Your Lordship will see that.
Yes.
Then dearness pay appropriate to the basic pay. Correct?
Yes.
And the third element would be dearness allowance appropriate to the basic pay plus dearness pay at the index average of 536.
It doesn't define the dearness allowance separately.
No, it doesn't seem to. You're right.
Dearness allowance is not defined, that means.
No. It's a percentage which is notified from time to time.
Yes.
And which, in terms of which we pay.
So this formula of 536 bracket 1982
1982
equal to 100 is a formula for existing emoluments, not for dearness allowance. Not for dearness allowance. It is for existing emoluments.
Yes, it's for existing.
Yes, but
it is for existing.
Not exclusively for dearness allowance,
Yeah.
but it is for existing emoluments.
Yes.
Dearness allowance is a part of emoluments.
Yes. I would agree with that.
And not independent.
Yeah.
Yes.
It's an element.
Yes, we are trying to understand.
Yes. So this is the notion of large existing emoluments which is to be taken. On this existing emoluments, the government may, in its discretion, in terms of paragraph 10, please just see. Yes.
Is that 10-0?
At page 166, which is what I had just placed before you. 162 at 166. This is the first memorandum of 23rd February 2009. Your Lordship has that? Correct? So it describes itself as a clarificatory memorandum on the West Bengal services, the 2009 rules, and on allied matters dealt with by the 5th Pay Commission. Correct? It deals with a large number of issues, and we are concerned primarily with paragraph 10 at page 166. Your Lordship has that?
Yes, please.
Consequent upon revision of pay of government employees in accordance with the 2009 rules, the dearness allowance to which a government employee is entitled from time to time since first day of January 2006 needs to be related to pay in the revised pay structure, and a necessary government order in this regard has been issued with the Finance Department memo of 23rd February 2009. So this is moving forward. This is what the DA will be. And the DA will be as prescribed at page 168. The period is indicated and the rate of the applicable rate of dearness allowance per month on basic pay is also indicated at page 168. May I just complete this this document at
Yes,
page 168?
yes.
So please go over to 169. Your Lordships have seen the rates. The payment of dearness allowance under the order from the dates under this order from the dates indicated above shall be made after adjusting the installments of the dearness allowance already sanctioned and paid to the state government employees with effect from 1st April 2008, 1st June 2008, so and so, with order dated so and so, respectively. The term basic pay for the purposes of calculation of dearness allowance shall mean the pay drawn in the revised pay band, including the grade pay and NPA, where admissible, but shall not include any other types of pay. In the case of employees who do not opt for the revised structure as per the West Bengal Services Revision of Pay Allowance Rules 2009, the pay shall mean basic pay in the scales of pay as per the West Bengal Revision of Pay Allowances Rules 1993, plus dearness allowance as sanctioned by the state government employees with effect from 1st April 2007 in Finance Department so and so. The dearness allowance admissible in paragraph 4 of this memorandum shall be rounded off to the nearest rupee in each case. So this is a series of memorandums. And may I take you to page 170? 170.
Yes.
So the earlier one which we saw was 23rd February 2009. Now please see what happens on 9th December 2009. Grant of dearness allowance to the state government employees and further ad hoc increase. Your Lordship has that?
Yes.
The governor is pleased to decide that the whole-time state government employees drawing basic pay up to so and so shall draw dearness allowance at the rate of 22% with effect from December 1, 2009. So the earlier figure, which you will see last line on page 168, 16%. Your Lordship has last line on page 120, 168, 16%.
Yes.
Now, that was in February,
Yes.
with effect from April 2009, has now gone upwards to 22% at page 170. Likewise, since we are on this, please go to page 172. Just mark the third line, 27%. 6th April 2010. And with effect from April 1, 2010.
Yes.
Have your Lordships marked that? 27%?
Yes.
Yeah. Then please go to page 174. 35% from 1st December 2010. The date is 23rd November 2010. 35% with effect from December 1, 2010. Your Lordship has that. And then I'll just end with the one at page 176, which is 45%. We'll give you a table, Bharat, so that it will have all
Yes.
those.
Yes.
Yeah. Yeah. You have it.
Yes, it is.
Should we hand over a table just now to the firm? We've got. Just
Ready, you give it, no.
Yeah, we have it. Just give it to you. Give it to them.
Yes.
So someone has to follow the rules. The second point is my computation in terms of the rules. Sorry.
I'm not saying that don't argue your case.
No, of course not.
You argue your case, but
Yeah.
just we are trying to gather
Yeah.
the difference between this index average and AICPI.
Yeah.
Just enlighten us.
Yes.
It is not against you. We are just trying to understand the list. You're just trying to understand.
No, I'll endeavor to supply that. I mean, what I have understood. But just have a look at this. Please just take up this sheet, which has just been handed.
Yes, we have.
Right. Now, instead of going from memorandum to memorandum, just please see what has happened. What you will find as far as the government West Bengal is concerned, there is a periodic application of mine. Having regard to the periodic application.
Their grievance is not against this percentage.
No, their grievance at the end of the day is,
that the same percentage would fetch more in terms of rupee under AICPI and less in terms of index.
So your lordship is absolutely
what we have understood.
No, actually, what your lordship. So what
till this time.
Yes. So let me. My understanding is also similar in the sense what the tribunal has required to be done in terms of this revision and revisiting and coming up with principles is to shift the base. I have a base.
Understood.
Sorry?
That your case is that if the rules say that it has to be on the basis of index average, tribunal should not have or could not have shifted the whole calculation to AICPI base.
Yes.
That is what your argument is.
No, this index average of 536, just please have a look at that, page 127. 1982 is 100 rupees. So as and when this particular rule comes into force in 2009 with effect from 2006.
Mr. Devan.
Yes.
Sorry. Kindly come back to volume 2, page 484, para 33.
Yes. Para 33. Yes. I'm on that.
We appreciate your submission that the tribunal could not have legislated, could not have issued a mandamus in the
legislate.
Not difficult. But we are only trying to understand on what basis or how this AICPI came to the knowledge of the tribunal and what was the basis for it to give such a direction. Because you have invited our attention to the statutory provision, which is the rules, the ROPA.
Yes.
And you have invited our attention to 3C Roman 3.
Yes.
Which speaks of index average.
Yeah.
So we are trying to understand what is the difference. My query
Correct.
is
That's the query.
that it speaks of index average.
Yeah.
Where does this AICPI come from?
So
and what is the difference between the two? Or the other? Please, maybe not. It's almost lunchtime.
Yeah.
After lunchtime.
I'll revert.
Begin.
But if I may just hazard a guess before lunch. So essentially, what is the operative direction, as far as I am concerned, on my understanding is that the central government follows a certain methodology insofar as AICPI is concerned, including periodic revisions as far as the base figure is concerned.
We want to understand what is this concept of AICPI. Where does it come from?
All right,
and what was the basis on which the tribunal came to such. That's what
I'll try and just supply a note. Very good. I'm grateful.
We'll continue after.
walking है या गाड़ी?
वॉकिंग भी जा सकते हो, गाड़ी
So they were close.
No difficulty, please continue. No difficulty. Mr. Devan, continue, please. No difficulty. There's a small matter, that's it. Not a small, but a very, yes. What do you say?
That's a human angle, my lord, if your lordship can confirm.
He was showing no remorse at all.
My lord,
Even in the counter, he files again.
My lord, if your lordship, my lord, doesn't.
You understand? That's why my lord says.
He always said
yes.
Some apology. We also persuaded. One sorry word. But I must tell your lordship, when he was taken to custody and produced before here and bail was granted, he has already undergone about 21 days. And then Lord, here now all these time is
पहले की बात है अंडरगोन कर दीजिए The petitioner has been sentenced to 2 months imprisonment by judgment and order dated 15/7/25. Then amicus curiae, senior counsel Mr. So-and-so, appearing as amicus curiae, pointed out that previously also, the petitioner has suffered 21 days imprisonment before being granted bail by this court. Can you point out that order?
Yes, my lord, it is there, my lord. If you lord look at order.
With the order dated so-and-so. He thus
office report
praised that a lenient view may be taken and the sentence awarded to the respondent contemner may be reduced to the period already undergone by him. In view of the submissions, Learned amicus curiae has also requested that in view of the vexatious petition, vexatious matters which the contemner has been filing in this court, a restraint order may be passed to the effect that the contemner shall not be permitted to file any such fresh PIL in this court. Taking note of the submissions advanced by Learned amicus curiae, we hereby reduce the sentence of 2 months simple imprisonment awarded to the contemner with the order dated 22/7/25 to the period already undergone by him. We further direct that no further public interest litigation petition filed by the respondent contemner shall be entertained in this court.
Obliged, my lord, much obliged.
We appreciate the assistance provided by Learned amicus curiae to this court in these proceedings. Order to the jail concerned forthwith.
Much obliged. Your lordship magnanimity can much obliged, much obliged.
after the part heard. So you can continue. You want to make a mention?
Your Lordship, item 36 is listed, and I mentioned being made about 10 days back to the urgency.
It will remain in the list, but we can't give you a proportional.
Tomorrow, if it can be.
It will not come tomorrow. Tomorrow is not a non-miscellaneous day, only unless it's a bail matter. It's not a
Non-bail matter,
then it won't come.
it will become infructious, my lord.
It won't come otherwise. We'll have to wait and see if we reach it after this part heard, then please wait. Otherwise, it may not come. It may not come tomorrow. If it doesn't reach today, non-miscellaneous day matters will come on Wednesday and Thursday only if they are bail matters. Otherwise, they don't come.
And it will become.
Please wait and see.
Yes, please. Your Lordship asked me, my lord, to explain my conduct as to my lord, how. Lordship will kindly see, my lord. My friend has shown, my lord, number in two documents. One is invoices, second is the LC. Now, my lord, as far as invoices are concerned, invoices is a document, my lord, which is there.
Apart from that, the lifting of 2,000 metric tons. That is obviously relatable to this.
I'll show that. That also I'll show. Now, my lord, invoices are their document. Now, as regards LC, your Lordship will appreciate that LC, my lord, for opening of an LC, I need a contract number because though it has been my specific case that we were operating only under a written email, then email will not be accepted by the bank as a contract for issuance of a BENGAL or opening of a LC. Therefore, Lord, this number has been used. Now, please see, Lord, the page 439 onwards. Kindly see, Lord, the LC which are opened. First, your Lordship will find, Lord, my friend has placed on record, Lord, 2-3 LCs. Now, please see, Lord,
2 LCs.
yes,
not 3.
Page 439. This is LC dated, Lord. Date of issue, your Lordship will find from the top is 16/4/2022.
Page 4?
Page 439, Lord.
It's in volume 3.
Yes, Lord. It is in volume 3. My apologies. Now, your Lordship will notice, Lord, two things, Lord.
Yes.
One, LC number, Lord, that is ending, Lord, 30001. Irrevocable documentary credit number 035 LC 011. Your Lordship got it?
Yes.
Ending with 30001.
Yes.
Date of issue 16/4. Now, Lord, kindly come to the next page. It gives, Lord, contract number as correct, but the date given is 12th of April. Later on, Lord, beneficiary objected, and Lord, this was corrected.
The Lordship should pass an order. First of all, this slide here. There is slight typographical error in the second paragraph. Incorrect FIR number has been mentioned. There were 2 FIRs. 138 and 96. 138 is by me. 96
Now,
is
this
by
correction, your Lordship
complainant. Yes, sir.
Is Lord
Para 9, Your Lordship.
Crime case number would be
96. Very good. Great.
July. That is Lord in July. Lord,
Yes,
and your Lordship will find the email. That is Lord on at page 175.
Just and in a note on the specific point.
Foot of the page, Lord.
This is not 16/4/22. It must be 22/4/16. Date of issue. What you read out at 439. The date of issue, perhaps the American mode is adopted.
Lord, it cannot be 416, Lord.
16/4/22. It's 22/4/16.
Yes, Lord, your Lordship. Your Lordship.
Not 16.
My apologies. Yes. 22/4/16. Yes, it is in the reverse.
So that was the draft. My learned friend is looking, 439 is the draft.
Anyhow, the date, because he read it out as 16/4/22.
It is.
That's why I had it down and then I looked at it. It's actually
Great.
it's 22/4/16.
460. Now, please see the email at page 175, that which is in volume 1, which was shown to your lordship.
Yes.
Subject SBLC amendment. This is the LC which was amended.
Yes.
And that was done in July. Now, may I request your lordship to come back to the other LC, which is on record, and that your lordship will find in volume 3 once again. And it is at page 445.
Yes.
Now, this is LC number 220005. Date of issue is 17/11/16.
Yes.
And your lordship will find 45A, contract number same, dated 15 November 2016. This was not amended. Now, what I am pointing out to your lordship is that yes, it is correct that I use this number, but that by itself does not show either my intent.
You also furnish the 2 letters of credit which are relatable to that contract.
I'll show how I furnish them. But by this alone, what cannot be shown.
Well, it's not alone also. There are multiple acts on your part.
What are
You
the
live
other
2000 metric tons.
Now, please see
You
how
furnish the letters of credit.
Correct. Now,
You
please-
correspond with them quoting this contract number.
No, it is not me. They write, they
And you reply.
I reply.
You reply
Where-
by quoting the contract number.
So where this contact number appears, I have shown to your lordship, it shows as forwarded. Because I reply, then it comes as forward.
No, the other letters which were shown to us, when you said that you are not going to commit a default.
Please.
Where is that letter, Mr. Banerjee?
Yes.
That you will not be committing a default, you said that into that.
8 September.
Please see page 197.
185.
Outside 181.
197, this is
186 stop.
186.
We are in no way going to default anywhere in the contract.
Forward. It's only to my notice of bill 181.
Now this is the only letter which my friend has shown.
Further.
But there this subject would have to be written by you. It doesn't come automatically.
No, let me.
When you reply,
Yes,
the subject portion is entered by you.
no.
Of course it is.
Lordship,
We all use email, Mr. Bhatt.
Lordship, just see
When I reply to a mail which comes to me with a subject,
please.
that subject doesn't get automatically repeated in my reply. I have to enter the subject portion myself.
Just allow me to respond why I send. When I write subject and I write this number, then it will be contract number so and so. When I reply to their mail wherein they have written the subject, then it will come as forwarded contract number so and so. It is not that I write this number. It is a reply to their mail. That's why the subject shows forward. Now please see one more document.
You will have to tell us one thing. All these acts on your part, we've heard the matter long enough.
Yes.
All these acts taken together cumulatively show that you have done certain acts in furtherance of this contract. You lifted that 2000 metric tons, which is relatable to this contract. You furnished 2 letters of credit, which is relatable to this contract. Then there is correspondence. Correspondence, you may have a point in saying that it needs to be read in a particular way. But the other 2 acts are sufficient to infer that you have acted upon this contract, which is all that we need for making out that prima facie.
With respect, no. Why? The other 2 acts, namely opening of LC, is in terms of the email dated 10th.
You refer to the contract there. The HDFC would not have got that contract number unless you gave it.
I cannot deny that.
Once you gave that contract number, that is conduct on your part, which is to be taken at face value.
With respect, using contract number alone would not mean that I have accepted.
And then you also left it to 2,000 metric tons.
Under the
Some oral contract.
Please see para 5 of
You
my.
come out with an oral contract thereafter. So you're appropriating and representing also.
Not at all. Please see para 5 of my plaint. Kindly see para 5 of my plaint, what I said.
Which page is your?
That is page 211, volume 1.
211.
I'm sorry. 211. I'm sorry, it is 215.
215.
Yes. No, we are under the.
This is the contract.
Yes, it begins at 215.
Yes.
Kindly see that at the foot of page 216. Although the time was not the essence of the contract, however, plaintiff provided performance guarantee as agreed in the business confirmation email dated 10th March 2016. Now, we have been operating under these business modalities, which is an admitted position, which they admitted in their application under section 45.
That will consider.
Now, only two judgments I wanted to show to your lordship. One is
yes.
Just give this.
There is a citation.
2009, volume 7 SCC 696, that is MR Engineers.
696. Paras?
Para just one. Paragraph 14.
What does it say?
The wording of 7.5, it was in the context of contract by references. Wording of 7.5 of the Act makes it clear that a mere reference to a document would not have the effect of making an arbitration clause from that document part of the contract. A reference to the document in the contract would be such that shows intention to incorporate the arbitration agreement also. Now, in this, the email nowhere states, and that they admit that the email nowhere discusses any of the business modalities. And had this been the case, then there was no need for them to send me a different arbitration clause, number one. Number two,
there wasn't much of a difference in the two clauses.
There are
the other differences. Where is the crucial difference between the two clauses which completely?
The crucial difference is, the crucial difference is, though in both the agreements, seat of arbitration is in London, etc. But the crucial difference is, in the first, there is no reference that there will be a 3-member tribunal and all that.
So it says as per rules.
With respect, parties, assuming it is as per the rules, parties have to agree that yes, as per the rules. Now,
you take it that you only read para 33 or
my case is that I
was never to demonstrate the difference.
How do you read
what is the difference between the two?
I do not have those
into ROPA.
Without knowing that, there is a question of
No.
In 2012,
just
when I agreed for the arbitration clause, I have signed and sent it back. I am a small trader in Himachal Pradesh. I did not agree for this. That's why I did not sign it. I did not send it back.
Now we are into
which they never insisted upon. That you send it back because unless you send it back, we will not cooperate. Because we were operating only under the email dated 10th of March 2016.
Yes, the High Court perhaps is that. But having Mr. Mr. Devan, having taken us only to this limited submission, we are putting it to you, just keep that in. That's
I can indicate the answer. There's no great secret at all, Lord, about what should be the, as my Lord Justice
if you don't mind, please.
asked, what is the
Mr.
list
Devan, if you
between
don't
the
mind,
parties?
just
Yes, of course.
Lord, the list between the parties is, my friend says that what is the rule that is 3C3, according to him, it is a static, stratified, fossilized AICP index.
correct.
According to us, my Lord, the word index itself means it is mobile with passage. That is all.
Where do you get that from?
From the rule itself and from the pay commission. My Lord, in fact, what is important is the pay commission, that is the West Bengal Pay Commission, actually said that you, the state government of West Bengal, from 1979, from times ago, have always kept in mind the AICPI index. But you, in fact, defrayed all these dearness allowance payments with considerable delay. But why don't you do one thing? Bring yourself up to date when you make the new ROPA in terms of our commission's recommendations, and then be in line with AICPI.
But from ROPA,
yes,
whether the recommendations are binding or not, statutory or not, that's a different matter.
Yes.
But ROPA
will not signifies that.
Where can you just
Yes, straight away.
Straight
Well, that, in fact, that was the most critical question which my Lord Justice MISHRA asked about the 3C. And that is not the heart of this matter. Please take the rule between you.
We have it.
Yes. Please take the clauses of 3C.
Page 127 of
That's right. Please have a look at this. My Lord, existing emoluments
mean the aggregate of
means the aggregate of existing basic pay. That's the first.
Correct.
The second is dearness pay appropriate to the basic pay. So, my Lord, what happens is when a revision of pay happens, there is a merger of the basic pay and the dearness allowance which existed as on the date. That is merged. And then we come to 3. 3 is important. Dearness allowance appropriate to the basic pay plus dearness pay. That is Roman 1 and Roman 2. What Roman 3 says is, how will you calculate DA? That is what was till now basic pay. You add the dearness allowance and merge it. So it is Roman 1 plus Roman 2. On Roman 1 plus Roman 2, Roman 3 will be appropriate to the basic pay plus dearness pay. Now, the crucial word is at index average. 536 within brackets. 1982 is equal to 100.
Average is defined there.
Index average.
It's not left open.
No, it is not left open. That is the point. If it is index average, when you use the word index, it itself suggests that there will be a mobility because the factor is given within the parentheses. What your lordship sees 536 within brackets, 1982 is equal to 100, shows that 1982 is equal to 100 was updated in the year 2005, which is 536. So, my Lord, it falls and follows the index. So, now what my friend, and my Lord, very astutely, if I may say so, because it's not really reflected in the judgments, is about this. Well, the point which was argued was, you have no rights, you have no rights. But this is a very astute point. Namely, it is stratified. That is, it is frozen in ROPA. And after that date, the index cannot move. Well, that's the contention. According to us, well, the very word index suggests mobility. And that is how this All India Consumer Price, and in fact, well, in that 2-page note which my learned Mr. Devan gave, please see item 11. That is enough for me, Lord. Item para 11 of this 2-page note. Please see para 11. The AICPI index rates are alien to the ROPA 2009. Now we'll not see the next few words. Say and except only for the definition of a component of existing emoluments in 3.1c3. So, my lord, AI CPI is not alien for 3.1c3. And AI CPI, my lord, index. The word index is most vital, my lord. Index means it is a discoverable value from time to time.
Space, that is the base.
This is one of the lists.
No, but as per this chart, which they are showing, the index, this index average is very
from here to here.
Yes, yes.
And it
according to
came
them
down to
also, it's not static.
Yeah, exactly, my lord.
The only
Which is
thing
that index which you will take into account? That is AIC. Sorry.
Adding to what my lord is saying.
Please, my lord.
See, 536 as per this chart is the value, average
In
value.
2005.
2005. ROPA comes into picture.
It comes in, Lord, I'll take it. I'm grateful. Let me explain this. Lord, that figure of 536, that is 1982 is equal to 100, is for the year 2005 because, Lord, the Central Pay Commission revised the pay with effect from from 2006. 1st of January 2006. That is why, Lord, this 536 becomes relevant. What the West Bengal Pay Commission said is, follow that same index because you have followed it from 79. And, my lord, as on the date of the application of the rules, they said it will be linked to AICPI. And our rules, my lord, came later. That is not because the pay commission was set up later. That's the state pay commission. But really, the crux is not whether it is index.
So, whether it is static or not, that is the
real. That is the new point, this novel point.
This 536 was arrived on the basis of AICPI.
AICPI. That is the point. The 536 is AICPI.
AICPI as on 1/1/2000.
Just a minute.
Calculation of future increase in DA on the basis of AICPI.
Precisely. In fact, not according to us, it's embedded. In fact, that indication of the figure 536 within brackets 1982 is equal to 100 clearly shows that the index of 1982 was being updated up to 1st of January 2006. So, Malone, the principle is that if you go by that indexation, then naturally, as and when this discovery of AICPI is done by the Bureau of Labor, that's one of the Labor Ministry, with the Ministry of Consumer Affairs, that is one of they've taken all India weighted average of what is called basket of goods and services, where there is an increase. And it is that inflation.
From ROPA.
Yes.
can we make out anywhere from ROPA? Anywhere else in ROPA?
Yes, I can show from the evidence in ROPA itself.
No, what we have seen.
Yes.
Reading of ROPA.
Yes.
Somewhere, anywhere else other than to see.
So these two words are crucial. The use.
Mr. Padwali, just one.
Always.
We will allow each one of you. What I told you. We are trying to understand. We are not finished. We are not concluded. He still is on his legs. As and when some queries come to us, there are two ways of proceeding. Either we keep quiet, hear them, hear you, and then
responding in that.
As and when doubts would come to our mind, we would pose questions.
So very good, Manoj. I'm only responding to that.
Just one.
And if we keep quiet, there will be some constitutional interjection in between.
So the doubt has come in our mind as to whether this is static or not. So one has used the word static. Now, how do we say it is not static? Because the figure is given there. From ROPA, can we make out that yes, it is not static? Is what we are asking.
Well,
not from the definition clause.
Very well, Malone. Would your lordship kindly see Roman 3 with me?
We've seen.
Dearness allowance. Can your lordship kindly see the next word?
Appropriate to the basic.
Appropriate. Now, what does the word appropriate mean? Appropriate to the basic pay plus dearness pay, that is Roman 1 plus Roman 2, at index average 536, 1982 is equal to 100. So, Manoj, it says that dearness allowance will be calculated on the basis of this index average. It is not indexation. And indexation is always a mobile figure based on the realities. And that is at index average. And the two words, index average.
It could have said index average as on today, which is.
Well, it is as on, in fact.
It doesn't say that.
No,
we are not the legislators. We are not.
No, I understand. There's no problem.
I mean, we are just, thinking a lot. It doesn't say.
Yes.
It fixes. It doesn't say as on.
Well, there's another, there's another rule.
Well, how do we read a statute? That's what we are.
No, I understand. And that is why, Malone, when you see these words, that is dearness allowance appropriate. How do you get appropriateness? By using that indexation. That indexation, Malone, in the very nature of things, is mobile. That is the point. That index, the word index itself means mobility.
Other than this.
Other than this, there are two other places in these set of rules where you will find.
Please, can you
yes, please. If your lordships will kindly.
If you don't mind, just
please just see, Manoj, for a moment. If your lordships will be good enough to see rule 7.
Fixation, we've seen this.
Yes, rule 7. Fixation of pay in the revised pay structure. The initial pay of a government so-and-so will be governed and formed from first day shall unless so-and-so otherwise be fixed separately in respect of his substantive pay and so on. And then your lordships will find, if you come to the proviso note, the one above note 1.
Yes.
Provided the pre-revised dearness allowance appropriate to the existing non-practicing allowance admissible at index average of 536, 1982 is equal to 100 shall be added while fixing the pay in the revised pay band and the amount of non-practicing allowance at the rate so and so. So, Malok, as on the date of revision of pay, you actually employ this formula of indexation. That is to Roman 1 plus Roman 2, you add this index formula. But that index formula means that as and when it changes from 536 and it goes elsewhere in that sliding scale which was shown, then Manoj, it adjusts itself. So Manoj, really the rule is one for adjustment in a pay band. Manoj, in a pay band, there's an adjustment. Okay. This is the point. But I must say, Manoj, it's a brilliant point taken for the first time. I have no objection. The point is a good one. It should be dealt with.
Just 1 minute to add, with your lordship's kind permission.
Yes.
Please see the same definition, dearness allowance again. Your lordship said, where does the indexation come in? indexation comes in by the use of one expression and some words. It says dearness allowance appropriate at the basic pay plus pay at index average. Index average is a well-known expression, as Mr. Divan's note number 3 and 4 points, it showed to your lordships that this index average is given by the Labour Bureau twice a year on 1st January and 1st June. I'll just read point number 2 and 3 which he has said. This index average is published by Labour Bureau, point 3. The Labour Bureau revises the index average twice a year on 1st January and 1st June. The broad purpose of this index is to enable adjustments with respect to inflation. Therefore, dearness allowance, as we all know, has two components. Dearness allowance appropriate to basic pay, which is fixed when the pay revision takes place by the pay commission. And the second component of dearness allowance is dearness pay. Dearness pay is never fixed. It is always linked to inflation, which is consumer price index. So therefore, your lordship may see the plus dearness pay at index average, and we know index average comes twice a year. And why should it slide? The next 82 equal to 100 has to be given some meaning. If 1982 is equal to 100, when I'm getting pay in 2010, we will have to see this 100 also, what it is. So therefore, this 82 equal to 100 is very crucial. So the rule tells us when you are fixing dearness pay on the indexed average, you will take 1982 as 100. Then what do? You see the index average for that year and give the dearness pay. Now, therefore, 82 equal to 100 is very crucial when your lordship actually sits down to interpret the rules.
See, you want us to read
no.
Add something to the statute. Anyhow,
No,
we look into
index. Now, two more points. Number one, the proof of the pudding is in the eating. On index average, they have been giving it to us. They have been giving it, but they have not been giving it twice a year. So what was our problem? Our problem was we went to the CAT-C. They are giving it, but they give it whenever they
will come back to you.
Yes.
Continue.
Great. Nonetheless, if you just go back to my note for a moment.
Yes.
I have just completed point 17. I'll just complete the rest of the note and then we'll move on. Point 18. In substance and effect, the DA percentage published by the central government is linked to and determined on the basis of AICPI average as published from time to time. Despite holding that there is no vested right in the state government employees for DA parity with the central government, the tribunal has brought about this parity by insisting that the state government, contrary to its own rules, adopts the methodology of the central government. The device employed by the tribunal is to make an express reference to AICPI and for DA to be revised on the basis of the AICPI number published from time to time, a notion absent in the 2009 rules. In effect, the tribunal has required a departure from the rules, amendment of the rules, by converting a static figure into a dynamic index average for the purpose of arriving at the revised dearness allowance rates. Now, this is, I just wanted to just put it court so that we are trying to respond to the court's queries. Now, Milord, just keep this note with you. And please go back to the ROPA rules, which your lordships will find at page 124, and we were on page 127 of the paper book, first paper book. Now, I want to just make a few comments on the definition of existing emoluments. That's where the notion of DA comes in. So please notice the expression first in Roman 3, dearness allowance appropriate to the basic pay plus dearness pay. Now it uses the words at index average 536. So there is no sliding scale. It fixes it at index average 536. Now the bracketed portion 1982 equals 100 refers to the 1982 series. The 1982 series proceeds on the basis that what was costing 100 rupees in 1982 is to be indexed upwards on an average basis. So the rules are very clear. The rules don't take a sliding scale. Otherwise, it would have said the index average from time to time. Simple under the AI. So you will find there is no reference to the AI CPI moving index at all. One. It specifically refers to the number 536. The 536 figure is indicated at with the expression at. So it's a fixed figure. It's a static firm figure. And on the basis of this figure, of course, we keep enhancing the percentage, which we find is required or which is within our capacity, etc. This is the only way, in my respectful submission, this particular rule can be read. It abjures, it stays away from a sliding scale concept. It adopts a static concept, but the static concept is also built in along with the static concept is what your lordship saw, the memorandum which was issued and which we referred to at page 162, the 23rd February 2009 memorandum. Paragraph 10. On page 166. Consequent upon the revision of pay of government employees,
that there was a 205 application moved by the petitioner, and that was allowed. And the court has taken that into consideration, that this is a defense plea subsequently set up. They filed a criminal case later on. They can place that before the.
But if there's, check and tell us whether there's any possibility. You just pass it over. You can contact your client for the phone.
I have it sometime on Friday, so I can get in this.
Next.
I will try.
Next Tuesday. List next Tuesday. Get the date. When counsel for the respondent shall ascertain as to whether the respondent is willing to attempt settlement of the dispute through mediation, considering the relationship of the parties.
Item number 20.
20.
May please, my lords.
Yes.
My lords,
Settlement is over.
the other side has a settlement. They tendered an unconditional public apology. They've also furnished an undertaking, my lords. My lords, the compromise deed, do my lords have it?
Yes. One moment.
We are seeking to bring that on
No,
record.
no payment.
My lords, we had foregone payment.
At least in white there's no payment.
No, my lords, we have, my lords, to be clear, I was forced, I was a widow, I was a government employee. I was forced to buy not one diamond ring, but 2 diamond rings, for example.
So
For the wedding, and I haven't claimed any money from them, not the money that I took to protect my daughter from his stalking, the case that I had to bring. ISRO brought a case. I'm an employee of ISRO. ISRO brought a case
Yes.
because he impersonated a sweeper and then hacked.
That you will only give a statement there and you are not responsible for the quashing of that case.
Because it's not my complaint. So we have foregone all of that. My mental health, my lords. I suffered from extreme PTSD, which is all. But now we've come to a compromise. So today, my lords, the only
The matter may be disposed of in terms of the fund.
my lords, the only thing I would request today.
You ask for liberty to revive the case.
Not at the moment. Today, I would request that 3 paras from the compromise be reproduced by my lords in the
Which
order.
paragraphs do you want?
My lords, 6, 10, 11, and 12.
What's the volume count for these?
6, 10, 11, and
I
12.
can just stand back, my lords.
6, 10, 11, and 12. 6, 10, 11, and 12.
6, 10, 11, and 12.
My problem is I can request him.
It is at its My lords can direct.
The volume is at its
That goes without
already.
You have a strong voice. That is a compliment.
It's a litigator's voice. One has to give a little less sometimes.
Some people say that you require a lot of lung power to argue in Supreme Court. This is what I have heard. I mean, after coming to this place.
Well, we hope that it's further up in the chain.
Very well. So we'll record this.
Make the compromise deed a part of the order.
Instead of one
or
you want the entire thing.
If my lords wish, otherwise these are my priority paragraphs.
We'll let the whole thing be. You can lift it from the soft copy. You don't have to type it.
We'll try and get it.
The soft copy is there?
There's a soft copy, there's a typed copy. My colleague will assist.
Yes.
My lords, just one thing I would request.
Yes.
And that is that there has been some difficulty even with regard to this compromise. Because what happened is that one of the cases was withdrawn and then refiled. And on the last occasion, my lords had directed that all of the parties either be represented through counsel or come on video. Now, we had also sent 2 emails requesting this because the court had directed that. That has not happened. So, my lords, my small request is that could it be kept, say 4 months from now or 5 months from now for compliance, just one additional date, just to make sure that it's all.
Want it to be closed today.
Not today, just one additional date, let it all be closed and then let us come back and report compliance.
I am representing R2, my lords. R2 is here. I don't know about others, my lord, because the brother and the brother are not in India. Lord, they are in Canada. That is what I've been instructed.
R2 is Viber.
R2 is Vyom.
R2 is Vyom, who is the bridegroom.
Who is the bridegroom?
R4 is the mother. R3 is the brother. And
He's the one who's represented by the
bridegroom to be is represented by me, my lords. He is here. In case your lordships want to speak to him.
Once the compromise is taken place.
But I doubt that things will not go through.
my lords,
You've already
when the affairs revive, what would happen is that I would then need to file a contempt application. So
You asked for an application for revival. You in fact said so in your prayer.
That's right, my lord. That prayer they have already sought.
Unnecessarily pending.
fair enough, my lord. So if my lords can make that clear, that it will only take an application for revival and not a contempt.
Perhaps in your settlement also you mentioned it.
In the application, my lord, that is the prayer. The lordship would have the
Or
application.
in your settlement, it's not there.
The application, you're right, my lords.
My lord, may I
Your prayer
Let's say,
Page
let's say
5.
something like that.
grant liberty in the event of any breach of the settlement. Petitioners may revive the present case.
And that liberty is always there, my lord.
So instead of a contempt, my lords may say that may make an on an application.
This specially petition was filed. Receiving the judgment in the order dated 5/3/2024 passed by the High Court of Punjab and Haryana at Chandigarh in CRNN 11563 of 2024 within brackets OIL. Also, the parties, the private parties to this litigation have settled their disputes and reduced the terms thereof to writing with a compromise deed dated 29/4/2025. Which the petitioners thereafter filed IA number 181296 of 2025 seeking to place the said compromise deed on record and advance the following prayers. Page 5. Okay, let's set up the page. Yeah. The terms and conditions of the compromise read as under. It's page 11, 1 to 19. Okay. In the light of the settlement arrived at point between the parties, we see no purpose in prolonging the litigation. You say leave granted.
Yes.
The appeal is accordingly allowed, setting aside the judgment and order dated 2024. You don't want the judgment to be set aside?
My lord, the judgment actually has quashed the criminal proceeding, my lord, the order summoning. If your lordship set aside, the case will revive against me.
Which case is this now?
My lord, this is
there are several cases. Which case is it?
Was against.
So it will have to be disposed of.
It will have to be disposed of.
It can be
So
disposed
which
of.
case is it though?
FIR number 122, my lord.
FIR 122 Baldev Nagar, my lord.
It is at page 137 of the.
So in your compromise, where is it mentioned? FIR 120.
Page?
Very pending. Very
Page
this one.
10, my lord.
Yes, yes.
Para,
Item
2.
Don't say that. Yes. The appeal is accordingly disposed of in terms of the aforestated compromise deed, the terms of which have been, terms and conditions of which have been set out herein above. The party shall be bound by the said terms and conditions and shall abide by them scrupulously in the event of breach thereof by the respondent. The petitioners are at liberty to seek revival of this special judgment.
My lords, one request if my lords will be willing.
Yes.
My lords, please so kind as to record para 4 of my application, which has the petitioner numbers and the fact that Mr. Vaibhav Sharma has been signed the compromise deed through a duly authorized power of attorney.
Which one?
This is para 4, page 2 of my application.
Page 2 of
Para 4. Yes.
Lords, here it just sets out who the parties are and the fact that respondent number 3, Mr. Vaibhav Sharma, has signed through his duly authorized power of attorney holder,
Yes,
which is before
one
you.
sentence there. Yes. The aforesaid compromise deed has been executed and signed by, give the names in paragraph. Yes. Well,
so great.
Grateful one.
Item number 21.
Please, notes, we request for a short password.
no, password was in the afternoon, council.
Because we are being led by Mr.
Whoever it
Nadkarni.
is, password is asked for during the morning session. After session, if you ask for a password, we need to devise an evening session.
Mr. Nadkarni's matter is going into court number 1. Item 2 is going on.
You are referring for the respondent number 2.
Yes, Lords. Lords, in case password is not possible, kindly fix it for tomorrow or next Tuesday.
Next Tuesday.
Next Tuesday. Obliged.
Next Tuesday. The request will then come for the respondent, the matter is adjourned. Please strong.
Obliged.
Item number 22.
Notice was issued for a limited extent, not as to
No one is appearing again.
No one is appearing. Notice has been served on respondent number 1, but the respondent number 1 is not chosen to appear in much. Lordship, I may just make a request, not let fresh notice be issued, not because why notice was issued with specific reason in the interest of the daughters. One daughter is aged 30 months, the other daughter is aged 28 months. So now both the marriage of both the daughters has to be performed. So if both the parents are together, then only marriage can be performed. So therefore, to facilitate a settlement.
Why don't you contact her and try to settle it?
She's tried his best. In fact, he's asking her to live with him, but she is not willing. In fact, I'm told.
No, you're directed to give a portion of your house to her.
That we are ready.
So you do that then. Maybe once she comes into the portion of the house, we can talk to her.
I'm living in a rental accommodation. So I'm saying that she can live in the rental accommodation. But she is not ready to accept. In fact, that is the reason why.
What is it that we can do if the outside does not come forward? The order issuing notice itself makes it clear that it is only for the limited time to.
May I just request a fresh notice, one last opportunity, fresh issue.
So the office report dated 4/8/2024 reflects that service of notice has already been effected upon both the respondents, but despite the same, they have not chosen to enter appearance before this court. Learned counsel for the petitioner seeks permission to effect service of notice afresh upon them for the purpose of settling their interstate disputes. Fresh service of notice may be effected by all modes, including custody.
Notice through trial court also.
Their what matter is pending then?
That's the DVC matter.
DVC is over, is it not?
No, it's pending, my lords, because I have to comply with the order. It's still pending, my lords.
Try to serve the party herself. There's no point in
serve the party, but through the trial court.
Not through the trial court. He said all modes, including custody.
That's all.
9th September.
23.
23 and 25 are covered by
Radhika Agarwal. Who appears?
I am appearing on
23
behalf
and 25 covered by Radhika.
Yes, sir.
Radhika Agarwal, you have the recitation. You got it?
Radhika Agarwal, yes. 2025
issues raised in these writ petitions was squarely covered by the decision of this court in Radhika Agarwal.
2025 SCC online.
My lord, I am carrying the judgment, my lord.
Just the citation is sufficient. We don't have to reproduce the judgment there.
It's okay.
25 SCC online.
Accordingly disposed of in terms there.
Interim brief is vacated.
Interim orders are vacated.
So
25 is also the same.
25 also.
Great.
Number 24.
Hello, Mayor.
Yes.
Well, 25.1 is also the same.
That is also the same. 25.1.
Okay.
24?
Hello.
Yes.
Please, Lords. From the beginning, my lords, what has happened is in the present matter, my lords, that the victim who is supposed to be a 12-year-old minor at the time of the incident, which is around 2nd of July 2016, she was keeping unwell, because of which she was being treated in the local village area. However, she was not getting well. And in the meantime, the father of the mother got ill as well, and the mother had to
Father of the mother. Grandfather. Grandfather.
Yes. He was also ill, so the mother had to go to visit her maternal house. So she took her daughter with her to Balia. There, my lords, they went to the district women hospital. There, my lords, some primary examinations and medical tests were conducted, my lords. During there, my lords, they conducted an ultrasound in which they found out, my lords, that she was in fact 3 months, few days pregnant. Thereafter, my lord, this happened on the 1st of July 2016. Immediately on the next day, which is on 2nd of July 2016, my lords, the mother returned back to the house where the victim and the family was staying. The father, which is the petitioner in the present case, my lords, they went to the police station, they filed a primary complaint, my lords, along with the medical reports, which were dated 1st July 2016. Well, the victim's statement was conducted under section 164 on 4th of July 2016, my lords. Thereafter, my lords, the father had submitted an application, my lords, before the Bihar State Legal Service Authority seeking permission for medical termination as well, my lords. That was on 28th of July. The abortion was conducted, my lords, at Sadar Hospital on 30th of July 2016. Charge sheet was filed 2 months thereafter, which is on 29th of September. The accused were granted bail by the Honorable High Court in the meantime in the month of October 16. Cognizance was taken on 10th November 2016, my lords. Charges were framed on 6th December 17, and thereafter, my lords, the prosecution brought 7 witnesses, and the statements and the cross-examinations were conducted, my lords. The PW1, my lords, was the maternal uncle of examination, was July 2016. Right, my lords?
Yes.
Thereafter, my lords, PW2 was the victim herself, who narrated and 4. The PW3 was the mother, my lords. She had also quoted the statement of the victim. Thereafter, PW4 was the learned ACJM who had taken the statement of the victim. PW6 was the officer. And PW7 was the medical officer who had done the medical of the victim after the FIR was registered. He was conducting of the accused, also deposed 4 witnesses in that, and my lord, the trial court in the judgment.
Please continue.
Thereby, my lords, both the accused persons have been convicted, my lords, under section 376 IPC for life with 50,000 each. Under section 6 of POCSO with life and 25,000, 10,000 each, which was, my lords, thereafter challenged in the criminal appeal before the Honorable High Court, and the Honorable High Court and the accused government has acquitted the High Court, and the Honorable High Court and the accused government has acquitted the accused, my lords, completely. My lords, during the entire trial, the prosecution has paid reliance on 4 documents. My lords, they have exhibited 4 documents. The defense has not exhibited any documents, my lords.
What are those documents? One you said was the medical.
One is the 164 statement, my lords, which the victim herself has exhibited. The 164 statement has again been exhibited by the learned ACJM who had conducted the 164 statement, my lords. The PW5, which is the petitioner herein, he has exhibited the FUD bayan, which is the initial FIR and police report, my lords. And thereafter, my lords, the PW7, which was the medical officer, has exhibited the medical report. So these are the 4 documents. Documents were also submitted by the prosecution, such as the transfer certificate, the letter of the Bihar State Legal Authority, and as well as the abortion medical documents, which were conducted subsequently before the charge sheet and everything was filed, my lords.
Yes.
Please, my lords. My lords, in regards to the age of the victim herein, the victim herself has stated her age to be 12 years at the time of the incident. The father, the mother, the maternal uncle, they all have stated her age to be the same, my lords.
What about the documentary evidence?
My lords, the documentary evidence, my lords, the transfer certificate from the government school which she was first enrolled with has mentioned the date, my lords, of her age to be October 2010, my lords.
Where is that? Which page is that?
1 second. My lords, if you may have page number 150 of my SLP.
150.
That's the school transfer certificate.
Yes.
Please, my lords. For day 10th month 2004, that is the year, date of birth as mentioned in the admission register, my lords.
Third October 2005. Date of birth is mentioned?
At 0.7, my lords. Date of birth as mentioned in the admission register.
2004. Anyone examined?
Not with regard to the date of birth, my lords. The IO had also, my lords, requested the medical officer to determine the age of the victim. However, the medical officer has failed to do so. In the 164 statement as well, my lords, the learned ACJM had written the age of the victim as 13 years. During the cross-examination, my lords, the learned ACJM has submitted that she had written the age not by going what the mother or what the daughter was, what the victim was saying, but as per her own judgment of what the victim victim's right age would be.
Where is that?
These are those. My lords, may I have page number 152?
Yes.
Yes, my lords. It is the third line from the bottom, my lords. I wrote the victim's age based on my estimation. My lords will find it in the TCR and the translation as well. Yes, my lords. Thereafter also, my lords, a slight in the initial medical report which was conducted on 1st July 2016.
Yes.
In that as well, the doctors in Balia hospital have also mentioned the age of the victim to be 15, which is coming in the ultrasound and which is coming in the letterhead of the hospital as well.
Very good.
Please, my lords. The victim, my lords, as well.
Show us how the High Court deals with the age of the victim.
Please,
Para 28.
Para 24 and 28. Page number 25.
Please, my lords. From the above contentions raised by the learned counsel for the appellants and judgments referred by the learned counsel, it is clear that, for instance, the age of the victim, who is a minor, is not proved during the trial. The place of occurrence as well as the accused persons who had raped the victim, the time of the incident has also not been proved in the trial.
What does the victim say? The victim's statement must be instructed. Page 13.
Please, my lords. Please, my lords.
She named the person.
Yes, my lord. She named the person, she identified the persons, my lord. She mentioned the time when it happened. She did not give the exact dates, my lord. She mentioned that it was after Holi, my lords. She mentioned the place, my lord, that one incident with the respondent one was in his coaching classes, which is just 5 to 6 houses away from her house, my lords. And with the respondent number 2, my lords, it was in her own house, my lords, in the afternoon. She has mentioned the places, my lords. She has identified the accused, my lords.
What are the other issues that weigh with the High Court for equity?
My lords, in addition to the place, the age, the place, and the people, my lords.
This
in addition-
223 CRPC.
Yes, my lords.
Where is that portion?
My lords, that comes
Paragraph 32 onwards, my lord.
31 onwards, my lord. May I read, my lords? Para 31.
There is no connection established between the two of them.
Right.
The victim has stated, my lords, that the incidences have taken place at different times, at different places, by both of them completely separately. The incidences have never occurred or taken place together by both of them.
Then how do you get over this then? How do you get over the non-applicability of 223?
My lords,
Which clause of 223 would you bring it under?
my lords, I would like to pay some reliance, my lords, on paragraph 41 of the judgment itself, my lords, in which the Honorable High Court has also quoted a judgment of this Honorable Court, Naseeb Singh, my lords.
Yeah. Paragraph 41.
Paragraph 41, my lords. Page 41 as well, paragraph 41, my lords. On page 42, my lords, if we see the clause 5 of the judgment, my lords, it states that a conviction or acquittal of the accused cannot be set aside on the mere ground that there was a possibility of a joint or a separate trial. To set aside the order of the conviction or acquittal, it must be proved that the rights of the parties were prejudiced because of the trial, as the case may be. And my lords, during the entire trial, my
And how
lords,
does the High Court say that there is prejudice here?
my lords, it's in the following paragraph, my lords. That as per the principles laid down by the Honorable Supreme Court and the two prolonged test satisfies that the case, that the joint trial conducted had prejudiced the defense of the accused and has successfully proven to cause a miscarriage of justice. In view of the aforesaid facts and circumstances of the present case, we are of the
So there's nothing on how the prejudice is caused.
Exactly, my lords.
Each of them was represented by counsel, is it?
Yes, my lords, they have given their statements under 313, my lords. They were given opportunity, my lords. They have brought 4 witnesses to support the testimony.
Each of them?
Yes,
All or
no, my lords, together 4.
4.
Together 4.
They had 2 separate lawyers? Or
No, my lords, they had one.
one lawyer appearing?
Yes, my lords.
Yes, what do you say?
Your Lordship will, if I may invite your Lordship.
You're appearing for?
I appear.
Who appears for the state?
Panel 1 and 2.
What is your stand?
That we are supporting the case of the petitioner, my lords.
You are supporting the petition. But you did not file an appeal.
Lords, we don't have the instruction.
Yes.
Yeah. If I may invite your Lordship's kind attention to the High Court's operative portions, my lord.
Yes.
Which is 20.
There's no discussion on how you suffer prejudice.
Lord, that can be seen, my lord, from the fact of what the question.
There needs to be a finding as to how you suffer prejudice.
No,
that's not there.
Those findings specifically in regard to
There
that
are
are not there,
no
but
findings.
not, there are some discussions there in regard the charges that were framed. There was
After extracting the judgment of this court,
my lord,
it was necessary for the court to record as to how it finds in the case on hand there is prejudice by the joint trial. There is no such thing.
my lord, the discussion further is there in paragraph 38 onwards, my lord, on 223.
38.
Paragraph 38, my lord, it starts at page number 38 of the impugned order.
Yes. Yes.
If I may read. The proviso of section 223 states that where a number of persons are charged with offences and such persons do not fall within any of the categories as specified in this section, the magistrate or court of sessions may, if such person by application in writing so desire and if he or it is satisfied that persons would not be prejudicially affected thereby, and it is expedient to do so, try all such persons together. As per the proviso, if therefore persons more than one are to be charged and tried together, the case must be brought within any of the clauses of section 223 of the court or any other provision of the court, and the burden is always on the prosecution to justify a joint trial. The court, however, when several persons are tried together, must clearly and explicitly distinguish between them and point out as to how the evidence affects them individually. When facts of 2 incidents occurring at different places in different times, there is no similarity between the incident, we cannot take such position.
That is not applicable. There is similarity between the incident.
Lord, there is none.
No,
the same girl is being raped again and again.
Lord, that's the only thing. Lord, the
Similarity is
victim remains the same, Lord.
No, the act also remains the same. What do you mean there is no similarity? Similarity between the incidents. The incident of rape is same.
Lord,
it is the perpetrator who is different.
Correct, Lord. The perpetrator, the offense is also the same. However, my lord, it's a clear, admitted.
And
based on
both
the
of you
prosecution
together and get the same counsel. So where's the question of your thereafter saying that we suffered prejudice?
Lord, with all utmost respect, my lord. Now, if we see the questions that have the circumstances that have been put to me under 313 to both of them, exactly the same. My lord, when there
the same questions would be put to you whether you committed the offense or not.
No,
the evidence which
if
is
your
being-
lordships will permit me to show me all the other findings, my lord, this is not specifically, High Court clearly records that we are not turning the conviction into acquittal only on the basis of 223, but there are several other reasons for the
So
same.
far as the age issue is concerned, there's no evidence to say that the girl is not a minor.
My lord, with
The
utmost respect, my lord,
burden is not on the girl to prove. Once there is sufficient material, the judge herself records that I looked at the girl and I recorded her age.
the magistrate, my lord.
Huh.
Right, my lord. However, there is a
How does the High Court say that there is no
I
proof
don't
that she is
rely
a
on
minor?
several decisions of this honorable court, my lord, and says that it is the burden, the duty is upon
It
the
is,
prosecution
they
itself.
produce the record. How does the High Court deal with the transfer
My lord.
certificate?
My lord, because that has not been even exhibited, my lord. The document is not exhibited, it's not on record, my lord.
What do you mean?
Now your lordship will see the documents that have been exhibited during trial. There are altogether 4 documents, my lord.
But this was part of the record though.
My lord, but it has to be exhibited by the prosecution, my lord. And even otherwise, my lord, there is a series of judgments of this honorable court that passing
Then
certificate.
if that doubt is
My lord.
there, the High Court ought to have asked for some ossification test to check her age. There is no question of letting a person who's raped a minor off on the ground that it is not clear whether she's a minor or not. There is sufficient evidence at least to indicate that there is possibility of the girl being a minor. The trial court would have seen her. The trial court would have examined her. The PW2's deposition is placed on record?
Yes, ma'am.
PW2.
Page number 140 of the SLP.
140. Now the judge who has recorded this, when he sees a person standing there saying that I'm 13 years old, he's not blind. If he finds an 18-year-old woman standing there saying that I'm 13, he's bound to record that. Where is the question? The High Court can't say, High Court doesn't even look at the person and say that there's no proof that she's a minor.
Respect, my lord. As per the provision, as per the judgment.
Also is not to be treated
my lord, but the age
in this fashion.
necessary.
The act is there for a purpose.
Utmost respect, my lord. Age,
Protect children.
absolutely, my lord.
High Court seems to lose completely
My lord,
that
age is still, my lord, has to be proved in terms of JJ Act, my lord.
she
as
is
per the
not even
judgments, my lord.
at the fringe. She is not 17. She's a 12, 13-year-old girl.
That's an oral testimony. I bow down. There is absolutely no question there, my lord. But however, the judgments of this honorable court clearly says that in
Those would come into picture when the girl is say 17, 16 also. When there is a possibility of wondering whether she's over 18 or whether she's less than 18. Not when it comes to a 12-year-old.
Lord, with utmost respect, my lord, the series of judgments which say that it has to be necessarily proved as per the JJ Act, my lord.
Is there anything
And this is
more that
there are
you
clear
can say?
findings.
This is definitely not a case where you ought to have been acquitted.
My lord, then the lordship can hear it, my lord, and then
No.
satisfied.
There's nothing more.
My lord, there are, my lord, there,
What else?
all the testimonies are there, my lord. There's
Where?
several other things, my lord.
What other things are there? Please show us what is there.
The place of occurrence has not been proved. Now, your lordship, the allegation is, my lord, with
She doesn't have to prove each nitty-gritty of everything that happened to her. She doesn't have to prove that you were wearing a purple shirt on the evening or the day that you came and raped her. That kind of nitpicking is not required. A 12-year-old who's raped multiple times, who's scared. She is put in fear of God knows her life, her family's life. So she's hardly going to remember the kind of trauma that she goes through. The mind blocks out things.
With utmost respect, my lord.
Where is the question of you saying that a girl who is raped like this is supposed to instantly push a button and recall every part of the incident that happened to
My
her?
lord, what the allegation is, my lord.
The mind will block out all that trauma.
No, your lordship will see the allegations and what is there in the pro. My lord, only then your lordship will be able to, appreciate the facts of the case, my lord, and how High Court
Show us
has-
one thing which we can hold in your favor. Everything that you're saying is basically against you.
No,
There's no question of expecting a 12-year-old to recall the details of the trauma that she was put through.
Call, my lord, he has not, my lord, the allegation is, my lord, that she was repeatedly raped for over almost 2 to 3 months, separately raped by both these individuals at different time and different places.
In all probability, you must have known each other, one told the other.
No, my lord.
Then obviously they both decided to take advantage of this
My lord, that she doesn't know me. Milord, it's an admitted case, Milord. It has come in the evidence.
No. You too. The accused obviously must have
Milord, I don't even reside there, Milord.
No, we don't know. We don't know.
Allow me to, Milord, with utmost respect, Milord. Allow me to show through all these testimonies, Milord. There are several contradictions. Mother and the victim herself says that she was not menstruating at the time of occurrence, Milord. Even then, Milord, the pregnancy thing has come. High Court reports that no paper pertaining to abortion was brought on record, and that is a fact, Milord. There are only 4 documents are exhibited.
The medical report is there of the doctor.
Medical report of the doctor was conducted.
Does he not say that she was pregnant?
She says she was pregnant.
Then where is the question? Why should we disbelieve the doctor?
No, we are not disbelieving the doctor, Milord. What High Court rather records, Milord, that there is no document which has been brought on record. So
Well, she was pregnant and thereafter she did not deliver. Obviously, there was an abortion.
High Court reports
There's no need to ask
for DNA, Milord. It could be only one of the accused persons, maybe, who might have committed it, Milord, with utmost respect.
If they did not conduct a DNA test.
And there are several arguments, Milord. I mean, with utmost respect, Milord, allow me at least 20 minutes to, Milord, show through the evidences, and none of the documents have been.
You have 20 minutes.
Milord, I'm so sorry. Now, Your Lordship, if I may first, Milord, just invite Your Lordship's attention to the findings of the High Court and then move to the, Milord, the testimonies. Now, Your Lordship, I am reading paragraph 25 onwards, Milord, which is at page number 26. The impugned
26.
Right. 26, the impugned order.
Yes.
Now, Your Lordship will say that the code lays down various provisions with regard to framing of charges against an accused. On perusal of charge sheet dated 6/12/2017, it is mentioned that the date of occurrence of the incident was on 2/7/2016. 2/7/16 is when the FIR gets registered, Milord.
Well, obviously that's a mistake then.
Right, Milord. It is mentioned that the date states that the daughter of the informant was pregnant for 3 months and a few days, as according to the treatment of the victim, which was done on 1/7/2016. Further, on perusal of the FIR and the case diary, the statement of the victim, which is in para 3 of the case diary, dated 2/7/16, she has stated that the first incident where Manish Tiwari, appellant number 2, raped her 3 to 4 months back during the time of Holi after a few days. And the victim has stated that Hare Ram Shah raped her while she was searching for her brother. It is factually impossible that the incident was reported on 1/7/2016 and the charge was framed for the occurrence of incident dated 2/7/16. But the Fatbian and the statement of the victim itself states that the incident had occurred 3 to 4 months prior to the registration of the FIR. That is, it's clear to us, Milord, that the charges framed are not in accordance with law and thus causing prejudice to the accused persons, because charges, Milord, have been explicitly framed for having committed the offence of rape on 2/7/16, Milord, and that, Your Lordship, I will show from the formal framing of charges, Milord. The framing of charge is the most basic step of the process of initiation of a trial in a criminal proceeding. Utmost care must be taken while the charges are being framed as a wrong framing may lead to denial of justice. Therefore, one should abstain from wrongful framing and joinder of charges as an insufficiency would vitiate the very basic essence. Paragraph 27. As per the depositions and the evidence, it can be contended that the victim was pregnant and she was examined in Balia. And as per the opinion of the doctor, she was pregnant for 3 months and a few days. But during the course of trial, the doctor who gave the opinion of pregnancy was also not examined. Any document relating to abortion has also not been submitted by the prosecution in the present case.
Who was the doctor who was examined then?
So she first gets examined, Milord, in Balia. She first gets examined in Balia, Milord.
That doctor is not it.
That doctor, no.
There's one doctor at least.
Right, Milord. No, right, Milord. I'm not pressing that, Milord. I'm just pressing on the reasons.
What you're reading out only shows that the High Court seems to go on technicalities. On the other hand, this denial of justice, it is the other way around that the High Court has done.
I'll show how prejudice has also been caused to me by present questions, Milord. Allow me to.
Because the FIR is recorded wrongly and the contradiction is manifest in the FIR itself. There's no question of any.
I'm not pressing on that reasoning of the High Court, Milord. However, the High Court was just pointing out.
You are reading out what we presume.
Now, Your Lordship, paragraph 28 onwards is the discussion on the law on how age is to be proved in a POCSO case, Milord. If I may read, Milord. Further, in the trial of POCSO case, the determination of age of the victim is a mandatory provision as per section 34(2) of the POCSO Act. The age of victim must be determined with the trial court, and this mandatory provision was not adhered by the London trial court. Section 34 POCSO Act merely prescribes procedure in case of commission of offence by child and determination of age by a special court in reasons under. Lord, then he goes on to reproduce section 34. Now, paragraph 29, Lord. Apparently, as per the bare reading of the heading of section 34, it envisages a situation where a wrongdoer is found to be a child. Section 34(1) stipulates that when an offence under POCSO Act is committed by a child, such child shall be dealt with under the provisions of the Juvenile Justice Act. Thus, in any situation, the special court ceases to have any further jurisdiction, and as such, juvenile in conflict with law is required to be dealt with as per the mandate of JJ Act.
How is that relevant? One of you is a minor?
No, my lord. It goes for the victim also, my lord.
No, this sentence is in relation to a child in conflict with the law.
Right, my lord. But my lord, there are judgments further cited, my lord, which says that the same law will apply.
You raise that issue.
Yeah, we have, my lord. And that is why all this discussion is there, my lord. Lord,
You raised the issue before the trial court that she is not a minor.
We have rather asked in cross-examination, my lord. Now, if my lord, the prosecution itself is not exhibited document, my lord, I will not try and demolish my case by further cross-examination and letting her the opportunity to get that document.
Did you put it to PW2 in her cross-examination that she is not a minor?
My lord, I had put it to the IO who was supposed to, my lord.
The victim herself is examined. Did you put it to her that she was not a minor?
Not specifically.
No, no question. No, it's a question of specific there. You hinted at it, is it?
I did, my lord.
You hinted to PW2 that she is not a minor.
Hinted, my lord, I will just.
Then we asked you to put a question, you said not specifically. So did you hint at it then?
Lord, I will just.
What exactly do you mean by saying?
No, Lord, there is a direct question with the IO that, my lord, that was so far as that is there.
Then the witness herself is the minor.
My lord.
And you don't even ask her. There is a question of saying that I asked the IO whether she is a minor. You don't put it to her.
My lord, with utmost respect, my lord, it's the duty of the prosecution. My lord, I'm relying upon a judgment, my lord. Even taking, my lord, acceding to the fact that even though that transfer certificate was on record and not exhibited and it's a technicality, my lord, the Supreme Court, my lord, in series of judgments said that transfer certificate is not a valid document of proof. Even for
one document at least, apart from the fact that the girl herself is seen by the trial court, JMFC speaks of having recorded her age. There is enough material to support that she's a minor.
My lord, there is
a question of the High Court saying there must be further proof of that.
No, Lord, I mean, because that is the procedure which has been laid down by the statute.
That is a hyper-technical.
There are only 3 documents, my lord, which, my lord, as per the
Beyond that, what do you have?
My lord.
Go on.
Now, your lordship, I will start with the testimonies, my lord. Then.
Yes.
Then show the testimonies. I may
what are the contradictions in the testimonies?
Reading from the trial court record, my lord, the translated trial court record.
Please wait.
The only difficulty is, my lord, that the names is still there.
Simply, they have assaulted the petitioner, and his limbs have been broken, and all those kind of things have taken place.
If I may answer, my lord. There is a final report filed. There are case and a counter case, my lord, with utmost respect. Final report filed. There is no injury, my lord, on the side. This is the second time such complaint have been raised. The first time such complaint was raised that we have assaulted is when I was granted bail, and after that they had moved for cancellation on the same thing. Now, once I was acquitted, my lord, all through the trial and all through the time, my lord, I was on bail. There was no, as such, any allegation of me having done anything. Lord, once I am acquitted, my lord, once I am acquitted, there was the final report has been filed. Allow me to place it on record, my lord. The final report has been filed. Right, my lord. Right, my lord. Right. And I have those injury reports as well. I have those injury reports as well.
We already placed on record this FIR.
That are additional. The closure has come only recently, my lord. Along with those injury reports, I will place on record.
I have the video.
No injury, nothing, my lord.
I have the video. I can also place. the same.
Very well, my lord, but those, I'm sure those videos must have been given to the IO, my lord, and pursuant thereto those final reports have been filed.
You are financially well off.
I'm not, my lord, I'm a
You are
teacher.
Teacher means?
I'm a teacher, my lord, government teacher. One of them is a government teacher and the other one is an
Engineer, my lord.
You're an engineer.
The other one is the other was an engineer, my lord, who is having
And
a
they are
job of 20.
illiterate people. They are taking shelter of the legal aid services
My
authority
lord.
for abortion, for everything.
My lord.
They don't get a lawyer.
My lord.
A panel lawyer from legal services authority is helping them out.
My lord.
So the fight is, you can understand what is going on.
I absolutely, I am not saying anything on that, my lord. I am only trying to defend the case of the, my lord, accused persons, my lord. And based on the materials which have come during trial, my lord, and nothing beyond that.
These contradictions that you know.
So, my lord, I will leave aside all the other witnesses because they are mostly saying what was told to them by the doctor after that doctor examination. So, therefore, I mean, they are not very much relevant, my lord. But two witnesses are relevant: is the prosecutrix herself, my lord, and the IO, my lord. If I may read, my lord, from the trial court record.
It's already filed, is it?
My lord.
The deposit
Page number
will be
31.
filed now.
Right, my lord.
Read from there.
Right.
PW2.
Page number 31, my lord, PW2.
31.
Page number 31 of the, my lord, translated version of the trial court record.
We don't.
I have only the record. We have only very copy.
Translated version is also. There's a translated version.
Yes.
It's Indian.
The difficulty, you know, those names, name of the victim has not been
redacted. See, what is it that you want to do? Yes.
Yes. I may read.
Yes.
Earlier, I used to study in a government school. Now I study in an English school. The incident took place after Holi in 2016. It was afternoon. My mother and father were not at home, Lord. I was alone at home. I was sleeping in my house. Manish Tiwari entered my home and raped me.
He's the teacher or the engineer?
He's the engineer. Right. I was alone at home. I was sleeping in my house. Manish Tiwari entered my home and raped me. After raping me, he threatened me that if I told any one of the family members, he would kill me. Further, he said that I already knew what type of person he was. After 2-3 days of that, I went to Shivala to look for my brother Himanshu Kumar Tiwari. It was evening time. Hare Ram's Dalan is on the way. I asked him if he had seen my brother. He then pointed towards the Dalan and said that my brother is in that direction. When I went there, no one was there. The Hare Ram Shah came from behind and caught me. He took me to the Dalan and raped me and threatened me that if I told anyone, he would kill me. I was scared and did not tell anyone. After that, for 2-3 months, Hare Ram Shah and Manish Tiwari kept raping me. I felt sick and suddenly I started having pain in my stomach and vomiting. So I told my mother. Next day, my mother brought me to the doctor in Ehara. The doctor gave me medicines, but I did not get better. My mother's grandfather fell ill. My mother went to Balia. I also went with her. My father said to get my checkup done there. My brother and my maternal uncle took me to a doctor in Balia. The doctor tested me. He did an ultrasound test. He called my lord that ultrasound is also not exhibited. He called my mother and informed me. My maternal uncle brought me to home, and when I asked, I told him that Manish Tiwari Hare Ram had raped me. The next day, my maternal uncle brought me to Piro and report was written. I recognized Hare Ram Shah and Manish Tiwari that the residents of my village. The witness identified after seeing. The witness had told that she had recorded her statement in the court. She identified the signature. Your Lordship, from the chief, it clears, my lord, that this incident took place on Holi. The date is not
prior
on,
to Holi.
On the day of Holi, my lord.
After Holi.
After Holi.
After Holi, it's evening, my lord, afternoon is what she's saying, my lord. That is why we have said
after Holi in 2016, not on the day of Holi.
Very well, my lord. As far as my
The Hindi version says Holi ke baad ki.
What I understood, my lord, and from the other.
Not on the
testimonies
day.
also. So that is why I'm saying the date of the alleged occurrence is also not known. It's not been put to me, my lord. First thing, my lord. But I'm going to the. Now the case is, my lord, that she's 12 years old, my lord. And it has come in further prosecution. Let me read, my lord. Lord, currently I'm reading the cross-examination. Currently I'm studying at my maternal uncle village, Balia. I currently studying.
Read which parts are contradictory. Don't read the whole.
Now your lordship will see paragraph 4. So in the house, there are 4 people who live, my lord. The grandfather, the brother, the father and mother. House says nobody was present, my lord. My grandfather is around 80 years old. My grandfather used to go out for a walk in the morning and evening, sometimes in the afternoon. My grandfather is a patient of paralysis and can't go. My mother does not earn outside and stays at home. She does not do farm work. I never.
It does not mean that they don't go out of the house at all.
No, my lord. Allow me. Now your lordship will see. Now your lordship will come to paragraph 17, my lord. I will only read the rest.
Yes.
Paragraph 16, my lord. Sorry. And before that, in paragraph 12, 13, 14, what is recorded is at that place, my lord, that the alleged place, where the place of the victim, my lord, that house is surrounded by several other houses where quite a lot of people lived, my lord. And this incident is supposed to happen in the at afternoon, my lord. And no such, my lord, no such witnesses statement was taken or any witness has come in forward and supported the case of the prosecution that something of this sort had happened in the day hours on that particular day. Now, my lord, paragraph 16 is when I said something, he has scolded me, and when I tried to scream, he closed my mouth forcefully. I resisted. The clothes did not tear due to resistance. I was breathing. He closed my mouth. I did not get hurt while breathing. He held me tightly. He raped me for 10 to 15 minutes. I was conscious at that time. I don't remember if there was any blood stain anywhere or not, or it was in my pants. First thing she says, my lord, she doesn't know whether any blood stain or anything of that. Naturally, there should be, my lord, in the case of a rape of a girl who is supposed to be 12 years old, my lord, there should have been. However, in paragraph 18 itself contradicts. I was scared and it didn't show anyone the clothes. I washed my pants.
This kind of nitpicking will not help.
My lord, I'm just showing all those. I mean, facts, my lord. I washed on my pants on. There was blood stain. The next day after taking bath, I washed those clothes. At that time, I was not menstruating. Lord, this is the case of the prosecution itself, my lord.
At that time, not that she had not started menstruating. She was pregnant.
Mother also said.
At that time, she was not menstruating. That doesn't mean that she had not started menstruating.
What I intend to say, my lord, is supported further by the testimony of the mother. Mother says that she was not, she was at an age where she was not menstruating. I'll show that portion, my lord.
It means she is certainly a minor. This argument goes against you.
Lord, I am only on the aspect of, my lord, if she is saying that she was not menstruating.
You can't have it both ways.
3 doctors, my lords, have confirmed her pregnancy, my lord. The first was in Balia, the other was the medical officer, my lord, after the FIR. The third was.
Let him on. Yes.
Now, your lordship will see 20, my lord. I don't remember having any difficulty in walking after the incident. No such incident had happened to me before the first incident. I had no injuries in part of my body. I did not tell anyone in the village because of this. So naturally, my lord, I mean, there has to be some injury, my lord. There has to be bleeding. There has to be injuries, all of which she is saying there was none, my lord. And rather contradicts herself by saying that rather she, my lord.
Injuries will not continue for 3 months.
Right, my lord, but
injuries will not continue for.
But what she's saying, my lord, after the alleged occurrence, there was no injury. After the rape, there was no injuries. What she's saying.
She washed the blood off her pants.
But before that, she said that there was no blood, my lord.
This kind of this.
My lord, with all due respect, my lord.
We are not going to hold a magnifying glass to the testimony of a 12-year-old
because
who had to go through this trauma and then has to recount it in open court in the presence of God knows how many people.
Now, my lord will appreciate this, my lord.
You can't expect us to hold a magnifying glass to that and say, all right, she did not say this here, therefore she contradicted herself here. That is not how we look at the evidence of a victim of this.
There are 2 individuals being accused of this, my lord, right, my lord? There are 2 individuals. Possibly one could have done it, or both of them could have done it, or neither of could have done it, my lord. Now the question is, my lord, now even if there is pregnancy, my lord, however, High Court clearly records that no document was brought on record to show that there was a birth. However, if we assume that, my lord, how could we say, my lord, that it was both of them? It could be only one of them, my lord, who might have ultimately resulted in, my lord, pregnancy of that woman, that victim, my lord. Where there is allegation that sexual assault took place, all were there, my lord, in open areas which were surrounded by several houses. And this has come out in the testimony of the IO, my lord. And I'll show you, my lord. None of the witnesses.
He held her mouth. There was no possibility of her to scream.
Now, your lordship, what she says is, this is in regard one incident, my lord.
This is a young child of 12 years old. You expect her to be fully clued in as to how she should try to.
No, she
is petrified there.
My lord.
And then what exactly are you expecting? That she raise a hue and cry, fight?
My lord, that could be.
27 and 30 years old, my lords, at the time.
Now, your lordship will just appreciate this, my lord, with utmost respect. Now, my lord, your lordship will say, apart from these two incidents, individually being attributed to one and one, my lord, one first incident having taken place in the house of the victim itself, and the second one in the dalan of accused number 2. Now, thereafter there is allegation that they repeatedly, for the next 3 and 4 months, repeatedly raped her, my lord. Insofar as that allegation is concerned, my lord, no place, no time, no manner has been described even in the testimony, my lord. Nor in the charge sheet, neither it has come out in the testimonies, my lord. So, my lord will also consider this, my lord, while arguing. Now, thereafter, my lord.
How difficult it is for a child.
My lord. Sorry, my lord.
To tell it to people that I have been raped or I have been raped. It's only now because of this education, people are coming forward. Otherwise, I mean,
especially in a village, or a shame that attaches to that person.
I absolutely understand. I absolutely understand.
The person feels first that she is to blame. That is the first feeling that a child of this age.
All I'm trying to convey, my lord, is that completely distinct offences. My lord,
these are not cases which would be just foisted upon someone.
Lordship may send it for, my lord, may send it for retrial.
Not a case for retrial.
My lord, then allow me.
You've not shown us anything till now. Show us what you find in the IO's report.
IO's, my lord. I only wanted to point out those things, my lord, where she says that none of the.
Let us see what the IO says. What are the contradictions in the IO's deposition?
Lordship will set page number 43 onwards, my lord.
43 of this translated version.
Translated.
Is TW number?
TW number 6.
Yes.
Paragraph 8, my lord. I'm reading the cross examination.
Yes.
Now, your lordship, first paragraph 2 of the chief, my lord, I'm reading. After taking over the charge of the investigation case, I took the statement of victim in para 3. After this, I inspected the place of occurrence. The place of occurrence of this incident is hallway of one room of the FIR accused Hariram Shah in the village Lahiri Tiwarid under Piro police station, whose main door is north facing and it has a wooden door. In this room, coaching is done by the accused and it's told about the incident happened with the victim. In this room, 2 wooden beds, 1 motorcycle, drum chairs, etc. are kept. East of the place of occurrence is cemented brick house of Kameshwar Shah. There is pit chart after the government road in the west, Lallan Tiwari's follow land after the road in the north, and the house made with bricks and tiles of roof of Bhubaneswar Shah in the south. Nothing else of note was found at the place of the occurrence. I took the statement of witness Ram Sudarshan Tiwari in para 9. Again, I took the statement of complainant in para 12. I got the victim medically examined in para 17. I took the statement of Himanshu Tiwari in para 25. In para 26, I took the statement of witness Arun Kumar Upadhyay. I took the statement of witness Vandhu Devi in para 32. Victims 164 was recorded in para 33. I received medical examination report in para 40. In para 44, I received the supervision. Now, your lordship will just note, my lord, all those independent witnesses who were investigated, my lord, none of them have come, my lord, and deposed before the trial court, my lord. Now, your lordship will see paragraph 8 of the cross-examination, my lord.
Yes.
What a father does.
My lord is a shopkeeper. He has a small shop in the village itself, my lords. So he goes to the shop in the morning, my lords, runs the shop. That's it.
Paragraph 8, if I may read, my lord.
Yes.
In the ultrasound report annexed with the FIR, the age of the victim is mentioned as 15. I had requested to check the age of the victim at Sadar Hospital, Ara. But after seeing the medical report, it says that whether the doctor has given it or not, we do not have personal information about the same. I had come to Ara from Piro with the victim and her mother. It is not mentioned in the case diary when I freed the victim and her mother, but she was with me till the victim said statement under section 164 of CRPC and medical examination. Medical examination of the victim was done on this. Victim was recorded. 164 was the day after recorded. It is not the case that there are two places of occurrence in the FIR. The victim had told me in a statement that 3-4 months ago, when she was alone in her house, the accused Manish Tiwari had come to her house and raped her. This fact is not mentioned in the case diary. So the first time she says about the place of occurrence so far as one person is concerned in the testimony. IO says that nothing of this sort was earlier told.
Where is the
paragraph 10?
Where is the FIR?
Sorry, Miller.
FIR.
FIR, my lord.
My lords, FIR is page number 80.
Page 80.
The father got it recorded.
Yes.
Father got it recorded. There's no mention of any place of incident and all of that.
No.
And which is what is pointed out with the IO, that earlier in 161 also, not just the FIR, even in the 161 statements, Lord, nothing of this sort, this description and all of that was there. And it is only before the deposition that she said that this is what had happened. And your lordship will also consider, my lord, she's an 11-year-old girl. It's a holy, my lord. Admittedly,
After Holi.
After Holi. After Holi. Lord, even if we take it as after Holi, my lord. As per their own case, my lord, grandfather is 80 years old. Ill,
can walk,
does not,
he said.
Mother does not go out, my
He
lord.
said he can walk. You
Yeah.
think mother would only remain in the house?
No, my lord, I'm not saying. My lord, this is for Indra, but she's
He
saying that
lives
it has
one door, one house away.
Lord, what I'm saying is,
So if this man has been keeping an eye out, he will know exactly when he will be alone in the
but
house.
this is not an isolated incident, my lord. The allegation is that this kept happening for.
The later incident, she does not say that they took place at home. So we don't
It does
know
not say
where
anything, Lord. It doesn't-
once they put the fear of God in her, and then they take advantage. God knows where they raped her thereafter. From all that you have read, we don't see any possibility of giving you the benefit of
Now,
doubt.
your lordship, allow me to read the questions and the circumstances that have been put to these two individuals in 311, 313.
Where is 313?
Lord, 313 is at page 47, my lord, of the translated version of the transport of word.
Yes.
Question number 1, my lord. Your lordship has it?
Yes.
47. My lord. There is witness against you that you seduced victim, age about this, and raped her. What you have to say? There is also evidence against you that you kept on threatening victim to not reveal this matter. What you have to say? There is also evidence against you that you did not let this fact reveal before her family, and after her health deteriorated that this matter got revealed. There is also a statement against you that you had threatened victim that if you said this to anyone, then I would kill you. What have you say in defense? My lord, nothing has been put to me. When, where, how many times, on what date, my lord, nothing has been put to me for explanation, my lord. And exactly same question to the other, my lord. When there is a clear case, my lord, your lordship will see the next 313 statement of the another accused, my lord.
Same.
Exactly same, my lord. Nothing has been put to me, my lord, in 313. None of the circumstances, none of the incriminating material or the relevant facts which should have been brought to me that on this date this happened. Otherwise, how would I explain that on this day whether I was there or not?
The specifics are not there in any way.
Lord, all your lordships have consistently held that all
what did your
circumstances, my lord.
What did your witnesses speak about?
None of the, sorry, my lord.
Your witness.
He simply says, Lord, that I'm a man of good character. No, has always been there. The other one of them goes on to say that the girl doesn't live in the village. Now, it has also come in the testimony of one of the prosecution witnesses itself, my lord, that she lives in Balia. So there is some confusion that where she lives. The father says that he lives at two different places. There are two villages in where the family lives. So all those things, my lord, are completely unestablished.
These witnesses also don't really say anything much in your favor.
No, they simply say, my lord. I mean, these are all villagers, my lord, who say, my lord, that nothing of this sort was ever come to their knowledge. They say that I am a man of integrity.
Why would they know about it? You're doing it on the slide. You're hardly going to go around and tell everybody over.
No, of course, I will not say, my lord. I will not say, my lord. But when it's a case, my lord, where there is accusation of repeated sexual assault at different places in the village, and those places are, my lord, these are not isolated places. Those places are surrounded by houses where people live, my lord. It is improbable, my lord. It's highly improbable, my lord, and therefore, my lord,
the girl was pregnant.
Lord, but we have not, my lord, it has not been established as to who was the person responsible for it.
She said it is you. That is enough for us to at least believe that there is a possibility, and you never dislodged that possibility.
My lord, that was.
What is this enmity that you spoke of? What was the enmity?
There's no enmity that has been proved, my lord.
Then you yourself said that there's enmity, because of that they're saying this.
There's no enmity.
Your witnesses also don't speak of any.
No, there's no enmity, my lord. I'm bound down to that. There's no enmity. I'm not pressing on anything on enmity, my lord. And your lordship will allow me to just read 223, my lord.
Had some other molestation case also against him.
No, my lord, that was closed, my lord. That has not been further. That was closed.
No, at least the allegation was there.
Not ultimate, the allegation can be there, my lord, but it's subject to what happens in the trial, my lord, and I was exonerated, my lord. That thing is there. That cannot be read against me, my lord, with utmost respect.
Anyhow, your witness was asked about it, and he said, I didn't know that he had faced this case.
Right. My lordship will permit me to read 223, and my lord, whether this case comes under the proviso of 223.
223, even if it applies, the judgment of the Supreme Court requires.
Your lordship will simply appreciate, my lord, that when two persons are being tried together, and none of the circumstances, neither of them are put
witnesses on your own behalf. What is the prejudice you have suffered?
Prejudice is, my lord, that I am in my 313. I don't even know which date.
That is
which
not
place,
true.
my lord?
That
Two people are
23.
Lord, two people, my lord.
You wanted to argue
223.
313 examination is not part of 223.
No, my lord. 223 is when the cases can be tried together.
There you need to demonstrate prejudice. That on the face of it, you're not able to do.
Lord, with utmost respect, the entire case is mixed up. Two people are being tried together where they are not even being told that who committed the alleged sexual assault on what date, what place, my lord. Where do I get to explain all these situations, my lord, with utmost respect?
I think that's enough.
No, there are certain judgments that I was relying upon, Lord, so far as the age of the victim is concerned, my lord.
Age of the victim, we've already told you.
No, but your lordships have consistently held that, my lord, it has to be proven in accordance with the law, my lord.
judgments you wish to cite, you file a written submission.
I can file a written submission.
Written submissions of 2 pages, not exceeding 2 pages, along with the judgments you rely on. Both of you.
But positively within 1 week. Don't
I
do
will.
it.
Arguments
By-
for
I'm
judgment
back
reserved.
Friday.
By Friday.
Learned counsel for the parties are permitted to file a written submission not exceeding 2 pages, along with the judgments relied upon by the. Yes,
Item number 46.
26. You're for the respondent.
Yes.
Wait, petition.
Last time, the Lords asked us to file a service report.
Sorry?
Service report.
Service
Last,
report?
the reply has to be filed by us.
The rejoinder has to be
Yeah.
filed. So, file or not?
Yes.
26. 26.
Reply has to be filed.
Rejoinder has to be filed?
Rejoinder is yet to be filed.
It's yet to be filed. You don't need to file it.
My lord, it's a matter where I'm requesting for an opportunity to be heard before the High Court, my lord. If my lords will be pleased to grant that. Otherwise, my lord,
This matter I've not read, so you'll have to tell me what.
My lord,
I
my
did
lord,
not expect to go beyond 25, so
My
you
lord.
have to educate me about what this case is.
my lord, if my lords may kindly have order dated 28/3/25.
Yes. Yes.
Lords have it, my lord. It is a specific case of the petitioner that he had received the notice only on 25/11/24, and therefore he did not.
No, please.
Please, my lord. So my only grievance is limited, my lord.
What is it? So you want,
Only an opportunity, my lord.
he's not been given an effective
Sir,
opportunity.
If I filed the reply, service report has been served on, the summons have been served on him twice. Once through the company itself, and then.
No, but this last service was effected on 25/11. No, not correct?
Not correct. That's when we come to the reply I have filed.
Yes.
There are 3-4 dates which are relevant here.
According to you, when was he served with notice?
Lordship, on 34, Lordship may see the High Court. 34, the reply.
Yes.
The High Court order is there, 5th September 2024. 34.
Yes.
5th September order says the petitioner is in the middle of the order directed to serve a copy of the application upon the opposition.
This is the first date, is it?
First.
Very good. 5th September. Then
the last paragraph says the petitioner will be at liberty to pay adjournment for the court below. 7th. On 7th, your lordship, the order is at page 41, type copy is 42. The trial court order. Without adjourning, the court records that the matter is pending before the High Court. The accused advocate is also there on 7th. Learned advocate for the accused submits so and so. And then the court went on to direct the company to hand over the coal, despite the direction from the High Court saying that the liberty is granted to take an adjournment.
Then?
So the lawyer, accused lawyer was there on 7th. He knows that the matter is pending before the High Court. Then lordship on 11th September, the service report is there at page 35. It says that para 2, it has been served on learned PV and the opposite party number 2, which is petitioner here, through speed post. Now the speed post tracking is on page 38 and 14. It says that on 14th September, the speed post is delivered to the accused number 2, which is petitioner here. So on 14th
September,
on page 40.
Page 40.
Speed post tracking.
14th September.
Yes. So he has been served on 14th.
Then
he is not. He has not come to the High Court.
Then
on next date of hearing, that is at page 43, 18th September order. Is not represented. Part heard. Matter was part heard. On 19th, the court again directed the notice to be served, this time through the state.
Why?
The last para, because he was not represented. Learned counsel appearing on behalf of the petitioner At page 40.
Directed to hand over a copy of the application.
Yes. Who in turn wins?
Additional public prosecutor. Cause it to be served upon the opposite party.
Then this direction was complied at page 46. The ASI.
What is the status of the criminal case?
My lord, the criminal case, I am on bail and the charge sheet has been filed, my lord.
Cognizance have been taken.
Please, my lord. So
Then
trial is
once the High Court deemed it appropriate to have a fresh service of notice.
Yes.
And it is served on which day then?
On
25/11.
So
please, my lord.
Twice, my lordship,
No.
14th and then 25.
No, the second time it was not necessary.
Yes.
Once the service was already.
Because he was not there.
But the High Court deemed it appropriate to effect service of notice through the public prosecutor and the police station.
And in the
So that service takes place on 25/11 and the order is passed on 26.
26. With
In Calcutta and I am in Ranchi.
in tuned also, sir.
But
That-
still, it is, my lord, yes, you are acquitted.
First paragraph is
You will get this quantity of phone back.
My lord, may I, my lord, may I address?
is the accused.
This is what. Records that
Yes,
you
yes.
served on 25/11.
In spite of the service, no one has.
No, but it was served one day earlier.
Please, 25/9.
One day earlier.
On the impugned, also page number 1.
So on that simple ground, we'll set it aside. Because
My lord.
it was not necessary for the High Court to have ordered a second notice. But once it did so, then it ought to have given him an opportunity to at least come forward some time. 25/11, if the service is effective.
He has been evading the service. Lordship, he is the habitual.
25/11, you can't get away from the dates. 25/11, he served, 26/11, the order is passed.
14th also.
And he's away. No, that fades into insignificance once the High Court ordered the second service. Once the High Court ordered the second service, it ought to have given him some more time. If he was served the day earlier, then the High Court ought to have waited for at least a week.
But Lordship, apart from that, there are also material on record.
We won't go into the merits. On that short ground, we'll set it aside and send it back to the High Court.
Then in that case, Your Lordship may say that there's no expression on the record.
No, that's it. Please grant this appeal. This is by way of this appeal, the second respondent. You are the second respondent before the High Court?
Yes, well.
The second respondent before the in CRR number 3635 of 2022 on the file of the High Court of West Bengal at Calcutta. It says the order dated 26/11/2024 was therein. Having heard the parties and having perused the record, we find that the High Court ordered a notice in the aforestated case on first, where is the first service order?
First
We
service,
note that also.
page 41.
Page 34 is the first one.
First order is page 34, 5th September.
We find that the High Court ordered notice upon CRR, notice in CRR number 3635 of 2022 on 5/9/2024 in the first instance, and service of notice was effective upon the second respondent therein on 14/9/2024. Thereafter, the High Court heard the matter in part on 18/9/2024, but by order dated 19/9/2024, the High Court deemed it appropriate to direct service of notice afresh upon the respondent number 2 therein through the Salampur SALAN police station. Full stop. It is an admitted fact that this notice was served upon respondent number 2, the appellant before us, only on 25/11/2024, as was certified by the Salanpur PS in his letter of the same date addressed to the public prosecutor, High Court at the High Court. However, the impugned order was passed on the very next day, that is 26/11/2024. Obviously, the petitioner, who is a resident of Ranchi, resident of Ranchi, would not have been able to make necessary. Where?
Resident of Dhanbad.
Dhanbad. Would not have had sufficient time to make arrangements or to go over to the High Court at Calcutta by the very next day, and was therefore not given an opportunity of hearing before the passing of the impugned order. On that short ground, the appeal is allowed, and the matter is remitted to the High Court for consideration afresh after hearing all the parties. We make it clear that we have not gone into the merits of the matter, and the order is only, this order is passed only due to the fact that the petitioner had no opportunity of hearing after the service of the second notice. The appeal is allowed in the administration.
Thanks, Madam. So,
Yes.
4 o'clock, Mr. Reddy, there's no possibility of taking up your name. Why will it become infructuous?
Despite the pendency of the assessment, the trial court sent the documents for expert opinion. And once the report is submitted, it becomes infructuous.
No.
Status quo is done today.
No, you can't pass an order. Let it be filed thereafter.
The undertaking was given at that time, but they have violated the undertaking and they are.
The matter will remain, the matters, let them remain in the next case.
Next
to make a mention.
I'm sorry.
For Friday.
For only 1 second. When you entered inside, I was telling my brother that people should offer a chair to seniors.
I was quite happy in that.
No, it's okay. That's your magnanimity.
Youngsters should be a little sensitive to certain courtesies that they need to extend to older members of the bar. Designated senior advocates warrant a modicum of respect. You don't need to really, I don't know what is taught to youngsters anymore, but senior counsel need to be at least given that respect that you offer your seat to them when they are standing, older people.
At least offer them if they want to.
See, we always do that.
Yeah, one should do.
One must teach one's juniors about these kind of niceties. This profession is still considered a noble profession. Let us not forget that. You wanted to make a mention, Mr.
Yeah, there's a batch of cases at item 46.
46.
I'm requesting.
This water cess matters.
Water cess matter.
There
I've got a split verdict, and Imagine has delivered a verdict against the state. So it will take some time.
Yes.
Maybe a couple of hours. So I request a specific date on a Wednesday or a Thursday.
No, this can't come up on a Wednesday unless we grant leave. So if you prefer, we can grant leave and give a specific Wednesday stay. Who appears against you?
Who's against us?
State of Himachal.
No, state of Himachal.
Oh, you're appearing for the state. Oh, so we'll grant leave and give you a specific date.
Manoj, a specific date may be fixed. Manoj, we direct that the pleadings may be completed in the.
Yes, pleadings are still not complete.
Pleadings are not complete. Manoj, the office report.
IAs were also filed by the state asking for permission to collect this S. We've already rejected that.
Those have been rejected.
This collector has been stayed.
Therefore, there's nothing more pleading, that's all. High Court judgment is
Counter
there.
affidavits can be
If they
filed.
want to file,
If you want to file something, you file it. That's
it's a pure
Leave
precedent.
that. This for hearing on
Affidavit, my lord.
particular date that you want? Any specific date?
Wednesday in September,
September. 17th September.
oblige.
17th.
Do you apologize? May I take some Friday with?
Tuesday's matters, we will have miscellaneous matters.
Let's put the next Tuesday matters will be coming next Tuesday.
Next Tuesday.
Mine is 37, there's some.
Next Tuesday.
Great.
As an exemption to surrender, that has to be extended till the next day.
Unless we take it up, it doesn't need to be.
Because the last order said till next date, since it was
27.
the next matter.
We've not taken it up yet. Next date of hearing. Unless it is heard, there's no question of extending it.
I know it may not be taken then that I don't have the liberty to not surrender. If it is
Not taken up your matter, counsel, please understand that.
Your Lordship, we were mentioning item 34, my lords. I want 3 weeks to file a rejoint. I've informed the other side.
Very well. 34?
My lord, may I have my lordship permission in item 40?
No, 34, let us, any opposition to that?
No, my lord.
Very well. Let's not give the Tuesday straight out.
Obliged.
Item 40? 14 item.
Item 40, my lord, we have filed our Okalatoi, need 4 weeks time to file.
What's that passing you?
Looks in item 40 will the time for the petitioner, any fixed date may be granted after 3 weeks.
4 weeks now. 4 weeks. 4 weeks for counter.
For counter, my lord, for.
Well, the state may also, well, state is the main party, state may also in the meanwhile file
I
their.
don't know whether the state council is here.
Because they have entered appearance, well, Sankita Sharma has entered.
Notice to be filed by the next date of hearing, list on.
So any fixed date after 4 weeks, well, whatever happens.
And maybe allowed to give fiscal appearance.
For your doctors to write. So, I was it, okay.
Grateful, my lord.